Hey guys, we are back for part 2 of our day 142 catch-up. Sorry about my internet. It is still having problems from Milton, apparently, in our neighborhood, but we are back. If it goes down again, I'll just see you guys tomorrow for day 143. We left off somewhere in the middle of a large swath of evidentiary rulings. They're going through Lil Rod's Instagram posts, including some captions that show words like slat, YSL, slime, that the state wants to introduce to show the affiliation with the rest of the co-defendants and YSL the gang. They do take a short recess. We're going to pick back up with Brian Steele offering a counter argument to something involving Damone Blalock. So that's where we're going to pick up here.
Let's just be back at 1.
Can I ask you a question?
Yeah.
I think you said you want to think about, I believe it's Mr. Blalock's statement to someone else about joining the gang. And I'm sitting here and I don't know how that comes in. Mr. Blalock's not a party opponent, and I'd like you to look at a case if you're going to do that. If that's okay, it's Kirkland, Kirkland versus State. It's 318 Georgia 639, and it's a 2024 case.
Welcome back, everybody.
And it's in Division 4. And it actually cites the Kemp versus State case, which is what the state. And in that case, the Supreme Court makes it clear that the conspiracy must include the declarant and the defendant whom the statement is being offered against. And the court said that the trial court in that case gave a proper instruction limiting that statement only to the person who was on trial, who's co-defendants, only to the person making the statement.
Was it a RICO case?
It's a gang case. It's not. No, I don't. It's not a RICO case.
I think that might make a difference.
I don't see why that makes it a difference if we're under 24-8-803 D2, 804 D2E. I mean, that's what the state is traveling.
Okay, I'll take a look at it.
Okay, thank you. And the same in Kemp. Kemp has the same exact language.
I'll take a look at both of them.
Okay, thank you, Your Honor. Appreciate it.
And Williams. I'll look at
Judge,
all 3 of them. Yes.
how quickly do you need that additional case law? Simply because my internet connection is not very cooperative.
Well,
I feel you,
I mean,
Leah.
do what you can over the lunch break. Maybe you can find somewhere else. We've got a Wi-Fi.
Yeah.
Are you joined to that?
Yeah.
Maybe you can just move somewhere else. It doesn't seem to be great in this
Sure.
courtroom, or frankly, anywhere in the courthouse. Why we can't get that fixed, I don't know. But all right, see y'all back in an hour.
Thank you.
All right, so we're going to skip the break, but I wanted you to hear that Brian Steele is raising that objection. That's just a law and crime thing right here, right? Okay, yeah, we can skip that. And we'll be coming right back from the lunch break. See how fast these trial days go and you can skip the breaks. And looks like right about here. And hello to everybody joining in. Welcome back, welcome back.
I have a collection of drinks up here right now. All right, did anybody want to offer any further case law on that issue we were discussing before the lunch break?
Judge, I have been looking and looking and looking. I've got some references in federal cases to staying away from bootstrapping. As far as additional case law beyond that, I actually would, I guess, go back and do a closer reading of Kirkland versus State, the case that Mr. Steele cited. It does say in that, I guess kind of most poignantly, is that the co-conspirator conversation, allegedly in that case, needed a limiting instruction to be admitted only to that declarant.
It does not say it needed a limiting instruction.
No, it doesn't say
a
that
limiting instruction was given, and so they're saying there can't have been any error when the jury was told only considered against this one person. But I'm not sure that that answers the question of, it does not actually say, a limiting instruction was needed. So, I mean, I was just looking at that same thing, and I'm not quite sure how to, that's the holding or result we ought to be taking from that.
And Your Honor, if the state may?
Yeah, and actually, and there was not an objection on that ground at the time.
Right.
So I'm not even sure that, that was the basis on which it came in. Yes, Mr. Atkins.
So, Your Honor, a key distinction is, and I was reading Kirkland over the break, is it cites Kemp, but these co-conspirator statements that the state's discussing
Pertain to the larger criminal street gang conspiracy. So in Kirkland, if I'm not mistaken, they are talking about a more classic criminal conspiracy to commit a crime in and of itself. So I haven't read front to back Kirkland, but that's my.
So basically the distinction here is, are we conspiring to do one thing or one contained series of events, like we hijack a car and then rob a bank, but it's really all transactional. It's all part of the same quick storyline, linear event, versus this RICO charge where there's a broader criminal enterprise and the racketeering that we do expands a broader expanse of time and space. So Atkins is going to argue that the case law that otherwise would support like a linear transaction that could have been a conspiracy, that this is actually much broader because of that RICO statute.
My understanding. And so and the reason I highlight that is because when you have a criminal, the Kemp and the prognosy of Chavers, when you're talking about the larger criminal conspiracy of the criminal street gang, if the declarant making that statement and the defendants are a part of that same gang, it's basically like the equivalent of a party opponent admission is how it is. If you look at 801D2E and just read it. So limiting instructions are not appropriate if all the defendants in a trial are under the same criminal street gang. If the court finds that statement was made by a fellow gang member or co-conspirator of the larger street gang, whatever Kirkland is to make is not, it's apples and oranges for the context of this case. I would highlight for the court that the reason the state cites Kemp and Chavers is because it's talking about the larger street gang. Like, for example, and this is from Kemp v. State, 303 Georgia 385, Penn site 393.
I'm sorry, one more time. I'm trying to keep up.
303 Georgia 385, KEMP v. State. And the holding, in subsection I, it says the trial court was authorized to conclude that Watkins' statements were made. My apologies. The trial court was authorized to conclude that Watkins' statements were made in the course of a conspiracy. The first sentence after that is Kemp and Hogan's argue that Watkins' statements were not made in the course of a conspiracy because the conspiracy ended with Gray's death. But the defendants were alleged to have been part of a larger criminal conspiracy. And then it goes on to describe that. And again, the criminal street gang conspiracy is ongoing today. And so as long as the declarant making the statement and the defendant against whom it's utilized against were being it's in furtherance of that conspiracy, which in this case again is the YSL criminal street gang or criminal enterprise as in count one, it applies to all if the court deems that that statement was made by a fellow co-conspirator in that criminal street gang and furthers that street gang's purpose.
A big thank you to Chris for sliming somebody in the chat. Thank you, Chris Hayes.
Your Honor,
Yeah.
the closest I can get, and I'm trying to go back and make sure I'm reading it, I'm trying to compare the facts, is U.S. versus Olivia. It's a 1974 Fifth Circuit case, 497 F2D 130, Penn site 132. The court is talking about that there's a lack of case law for trying to decide whether there's enough independent evidence or what constitutes. We have never stated in explicit terms that the standard to be used by a trial judge in determining the sufficiency of the evidence. I'm sorry. We have never stated in explicit terms the standard to be used by a trial judge in determining the sufficiency of the evidence other than the hearsay. We find it necessary to go through those things. In that case, what they talk about being the relevant other evidence, which in this case it was not enough and it was vital and the conviction was reversed. The evidence used against the defendant there was his presence in a crowd where drugs were sold, telephone calls between that person and another person, that the appellant was in a beige Cadillac followed by the declarant into an adjacent parking lot shortly before the drugs, testimony of an officer that someone saw him in a parking lot, him driving away, a gun in someone else's possession. I'm trying to find something closer, but all of the, not factors, but all of the components which were analyzed whether this evidence was sufficient outside of the conversation were completely independent from that conversation itself. I'm still trying to find something closer, Judge. That's as close as I've gotten.
Okay.
And now remember, this all is like something that spawned before their lunch break. We skipped the lunch break and Leah said, hey, by the way, I'm also having some internet Wi-Fi issues, so everything's moving slow on my computer. And Leah's rushing and explaining, I'm trying to find something closer. I haven't done an exhaustive search yet. So what kind of sucks about that is oftentimes we see how much time is given, in my opinion, in one direction, to one side of the courtroom, to be able to prepare briefs and look for case law and find things that can help you make the argument you're trying to make. But time and time again, the short end of the stick seems to be given to the other side of the room, particularly a few attorneys. This is not the first time this happened to Leah. I think Miss Westmoreland was called out for it before too. Like really without any second chance being given. It was just straight out the gate. So, you know.
All right, and I don't know if it might be possible to see the record in the Kirkland case and figure out, if there was
It should be easily accessible.
a ruling that at the time of the trial that, hey, this is coming in under 801 D2E.
Judge, I may be able to sit in front of Odyssey and take a look. It was one of your colleagues here on that case.
Oh, okay.
Yes.
All right. I mean, I just sort of read, and I may be wrong on it, but that the court's sort of saying there can't have been an error because of this limiter that said don't consider it against Kirkland anyway. Sort of, we don't even have an issue here. I don't know. I could be misreading it, but.
If the reason that instruction, the reason there was no error is because it wasn't used against that defendant regardless, then I guess the thrust of it is it shouldn't be used against a defendant. Whether it comes in at all, whether a limiting instruction has that effect, it's not supposed to be used against the other defendants.
Yeah, but so the instruction actually was any out-of-court statement by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find it was freely and voluntarily made or whatever, which is not relevant for our purposes. But after the alleged criminal act has ended, it's sort of, and there wasn't like a RICO charge or a gang charge or anything like that. It was just a murder. And there are these two co-defendants, and I don't know if it's saying like, because the alleged criminal act has ended, there can't have been a conspiracy anymore anyway, or
I will look at the facts. I know off the top of my head, cover up after the fact still is included, even though that will have. Judge, I'll try to get some more specific information.
Okay.
I don't want to guess and speculate.
Yeah.
I'll try and actually find
Okay.
the facts.
All right. Anyway, which is sort of a separate issue than our other issue, which you're also going to try to find something better on. But anyway, so my ruling on that will stand unless you bring me something that.
Well, I guess that ruling will stand does mean that we would need to keep going through all of Mr. Blalock's records.
Okay. And then, Mr. Steele, it sounded like your argument might have been, why don't you just restate your argument for me that you made just before you gave us that site to Kirkland?
I'm going to ask the court if it comes in for limiting instructions, and I'm looking for proper cases for you to consider. But I believe that specific colloquy that you read, or that's at issue, I don't know how to identify, except the one where someone's saying, oh yeah, I'm in the gang and I was blessed in, or whatever the
Right.
words are. I don't see how that furthers the conspiracy, because it's just two people talking, hey, should I trust you or not trust you? I don't know why that is a furthering of the conspiracy. I think those are just talking about past acts, and they may be co-conspirators who don't know each other, or they may be gang members who don't know each other. So I don't know why that furthers it. But what I'm specifically looking for is Mr. Blalock's not here, and my mind is that any statement by him should be his statement. I do understand that any act or statement of a co-conspirator to further a conspiracy is an act against everyone, even if you join the conspiracy later.
Right.
But on this particular occasion, we don't know who one person is. We're letting in, it's like the tail is pulling the dog, because we're letting the conversation from an unknown person to say, oh yeah, this has to be gang related because of what's being said, when I don't know who that other person is, talking with Mr. Blalock. And so I think that we're so turned on this issue that I'd like the court to consider it. But I'm looking for better cases for you, that if you do let it in, it's not admissible against Mr. Williams or really anybody else here, because you have one person severed, or he pled. Your Honor, I think he pled.
Okay.
I apologize. Didn't he plead?
He did not.
Okay. Mr. Blalock pled.
Anyway, that's neither here nor there.
Okay, well, he's not here.
Right.
And then we have, to me, an unknown party. If somebody knows who that is, I apologize. I don't know who that other person is. So to me, I don't see why it passes the 801 D2E test, because I don't see how, just talking about, are you in
Can't be in furtherance of the
Exactly.
conspiracy? That's
Exactly.
the basis of your argument?
Exactly. That's my first issue. But if it
Okay.
goes beyond that, then that's a bigger issue for us, I thought. That's why I wanted you to look at that case.
Okay, and I think that was the main reason that Mr. Atkins was citing the Kemp case to talk about the liberal, in a gang case, there's the crimes, but then there's the further conspiracy of the gang and its continuing nature. And I read Kemp to say the Supreme Court, are very liberal on both whether something's in furtherance of the conspiracy, and there was another one that they were like, and we're also liberal on this. I don't have that one in front of me right now because I pulled up Kirkland, but Mr. Atkins, if you've got that case still up, what was the other? There were like two of the different prongs of the 801 that.
Yes, Your Honor. So
Was the other one during during the concealment phase, or?
No, it was
What was
during,
it?
so,
Maybe I should just pull it back up.
Your Honor, give me 1 second, and something the court just said related to Kemp, and this is Penn site 394. It states, at this trial, there was the Gangster Disciple Street Gang.
Right.
Detectives testifies about that. It says that Watkins, who was one of the defendants, would discuss his participation in crimes with Leah, an admitted gang member, helped establish that Watkins was also associated with the gang, which is kind of similar to Blalock, who there's other evidence is a member of the YSL street gang, like his social media, et cetera, that this other person speak with him. That in and of itself can be used, and they go further. They say the fact that the defendants accomplished the specific acts charged, which was the murder against Gray in this case, did not necessarily end their involvement or association with the gangster disciples, nor did the criminal street gang's purposes necessarily end with those crimes. And so I think the dispositive issue is if the court deems these statements or any statements as 801 D2E, there will never be a limited instruction with the fact pattern of this case. If the court doesn't deem them admissible or says they're hearsay, well, then they're out unless there's some non-hearsay purpose. But if the court, in this case, because everyone's charged of being a part of the same conspiracy, if the court believes that a member of that same conspiracy made a statement that furthers the conspiracy, it would be applicable to all and would never have a limited instruction.
Yeah. I mean, right now, I think that's correct, but of course, would consider further case law. But the court is instructing in Kemp that it's a liberal standard on both whether something was a statement was made in the course of a conspiracy and whether a statement was made in furtherance of a conspiracy. So, all right.
I will keep looking.
And they're kind of specifically talking about, you know, how it in the context of a gang and the cohesiveness of a gang and all of those things that the state has been arguing. And they refer to both of those as a liberal standard that we here at the trial court level are supposed to be using. Okay.
Your Honor, over the break, defense counsel and the state, we were speaking, given the court's ruling, what the state would like to do for, I think it would be efficient if the court permits, is to, the state is looking through the remainder of the Instagram that is left,
Okay.
with specifically Acts 79 through 81. And so we have whittled down some more, but the state would like to, if defense counsel and the court permits, give have a brief period of time to whittle it down further, present to the court and counsel. And if the arguments are, to Ms. Abbasi's point, they're going to be similar arguments.
Right. Okay. All right. That's fine.
Judge, my only request with that is we've been repeatedly requesting the whittled down version and we get something. And Misty Williams and I spend hours going through it, every single page prepared to discuss it. And then the state says, well, we'll narrow it down some more. And we do this over and over.
Well, I think they're narrowing it down some more now because some of your objections have been granted
Okay.
or whatever. And so they're saying, okay, well, we understand that reasoning. So from the universe that you most recently got, it'll be smaller.
If we could get a deadline of time just so we can plan on when that's due from the state.
We can keep going through these now. I don't think it would.
No, I don't.
But, it's probably only going to help defense counsel in terms of
That's
the
fine.
state's intending to reduce what we've
Right,
already.
exactly. Yeah.
Tuesday, Wednesday, just
I would think it would be before. My plan is to do it tomorrow, depending on when we get out of court today.
Okay. That would be great. So
That would
get
be
it to
great.
them before Monday.
that would be wonderful.
Okay.
Okay, so this was Friday, right? We were rewatching Friday. Atkins is like, I'll do it tomorrow on a Saturday. And Leah's like, heck yeah, sounds great. This would never happen if there were a certain different party in the room today or Friday. Oh, man.
All right. Okay. So what are we going to look at then?
We can keep going with the videos.
Okay. So we were on number 34 ending in 0944. Is there objection to that? Oh, no, that was, we dealt with that one. And that was, the state was going to see whether there was anything significant in the audio. And otherwise, do you know the answer to that yet?
Yes, Your Honor.
Okay.
We do not have to play that video with
All
audio.
right. So that'll be without audio. All right. So what is the next one that council has objection to?
Okay, that would be 7223, video number 35.
Okay.
It'd be the same cumulative.
All right. And should I?
Look, you want me to listen? We went through a few.
Uh-huh.
At the lunch break, and maybe withdrawn. We just want to pull up and confirm that that's one of the ones. Would you like to pay attention? Hold on.
So, Your Honor, there is another video that me and D. Williams were discussing that the state would be introducing for a similar purpose. And so the state would not be arguing to introduce 35
All right,
if there's
yeah.
another video that the state would, that I know.
So 35's not going to be offered. Next. Do you know which other ones aren't going to be offered?
Yes, Your Honor, and
Do Mr. Williams and Ms. Abbasi know that?
we were discussing that before we resumed.
Okay.
And what may be helpful in this case is there is a specific video that I know me and defense counsel spoke about that they're objecting to that I can play next. which begins with or ends with 1797 and starts with videos _1985.
Could the state possibly just delete the videos that are currently in the Dropbox if they're not going to play them?
Can y'all do that real
I don't know if
time
you can.
while
That would
we're
be very
in
simple,
the?
though.
I can. I'm also using this to publish for the court, but yes, I can delete. I mean, that takes
Okay,
no
go
time.
ahead and delete. I've got the Dropbox up, so if you want to get rid of the ones we're not going to need to think about.
Yes, Your
And
Honor.
they hopefully will disappear in real time.
Mr. Atkins, please just let me know when to refresh the page.
You can refresh every couple seconds. I'm going to just be deleting as we're going through these for efficiency's sake.
This is such a different experience when it's Atkins dealing with evidentiary issues and stipulations. Okay, this is kind of like it 2 times until they talk again. Okay, do they do this for a while? I know as soon as I move it to skip forward,
Your Honor,
they'll start talking.
There's only 2 more videos, I believe, that we have not discussed.
Okay.
Well, in this folder, and then there is we'll go through these first, but I'll play the 2 we haven't discussed. The first is the video that starts videos 1985 and ends in 71797, and I can publish it for the court if the court would like.
Okay. Well, no, I'm not on Zoom. So what did you say? It's 1797?
The last 4, Your Honor, are 1797.
All right. I'll just play it up here.
Yes, Your Honor.
And is audio?
Yes, Your Honor.
Okay. Oh, I'm going to have to, might need to start that one over. Sorry.
Go to normal speed.
All right. In the objection
Okay, it sounded like somebody was losing their lung in the background of that recording.
would be,
Cumulative and also relevance, because I don't know who the other people are.
and the response would be,
So, Your Honor, he says, you can't come on this block, and mentions 250, which is in reference to 250 Cleveland. And then the state views as well when he says Little Rod will basically shoot at you. He'll shoot at your fitted in front of Mr. Ryan, who throws up the YSL sign. He adopts that. He doesn't push back. And so it's a public display of don't come over here. He will shoot you. And so this is unique compared to other videos we've shown. And so the state does not believe this is cumulative and is relevant because it's a public display of do not come to this location or violence will come to you.
all right, overruled. And then
Steph
what
is
would
out here
our
going bananas.
last one we're looking at be?
Steph
So, Your
JK.
Honor, this last one is, it ends in 5,
It ends in 5684,
Okay, I see it.
and this is, I believe, 12 hours after the murder.
No
And so-
objection to that one.
Okay. All right,
Shout
so
out to
then
Steph.
is
Gifting 4.
this the
guys say thank
entirety
you.
of the evidence for this?
I believe they have 6 videos on the Word document.
And Your Honor, I will have to operate those for the court because.
Okay, all right, that's fine. Let me just join the Zoom.
This is my version of Flesh of the Gods slime umbrella. Gotta call it sprinkling. Steph JK is sprinkling. We're trying to take the word sprinkle back. So
Okay.
it's a less dorky word.
So, Your Honor, there's a Word document titled Ryan IG Live Stories that has 6 videos. So the state's going to be opening these. You have to open the Instagram return to play these.
All right. It'll take them a bit to pull them up.
Pulling that up. Well, I'm trying to think of something else we could. I don't want to waste the court of counsel's time, and so
Look at Judge Whitaker's face. There's music to her ears.
All right, I'm open to suggestions.
Yay, the Nutty Brunette got power back. Ah, I'm so happy for you. It is a struggle.
So, I don't know, Ms. Hilton, is there something you could be pointing us to in the meantime? Or, I don't know which, okay, it's not, have you screen shared yet? Because I don't see it.
I'm sorry, I'm sorry.
Ike is over here trying to get a record deal with YSL, the label. All right, Atkins.
Getting this pulled up.
We have it pulled up on our. Mr. Agnew is on the video.
Okay. Let's hope it goes faster than this during the jury portion.
yes, Your Honor.
We'll slow it down and listen to him. I think we're about to see a bunch of stupid stuff posted on social media.
If y'all want me to see, yeah.
Okay, so that's Woony Lee's tag, the @ symbol slime life shorty. Oh my god, why do we gotta watch this?
That shit bothers me. Find blood and they can't see me. All that mouth, cause him won't speak. Heard that girl inside the bed when he on his knee. The devil on me, that's what I'm told.
So, Your Honor.
This was posted on February 21st of 2019. The murder was February 23rd. I don't know if definitively these are the firearms, but there was both assault rifle rounds and a 9mm. And so it's this, the state believes this is unique and relevant because one of the timing, and two, the person he is adding is Woony Lee, who we've talked about earlier. And he shows both an assault rifle and a handgun in this video. So the state wanted to introduce this, given how close in time it is to the murder involving weapons of that type.
Okay, didn't we have something earlier that was being offered for the same reason?
Your Honor, that was a Instagram thread we did where I
They're gonna
believe
say it's
in,
different 'cause of
this was the
Woony
one
Lee.
where someone was trying to buy
5 or
guns.
6.
Correct, Your
yeah.
Honor.
So pick between them.
We will use this video, Your Honor, and redact, I will find that PDF page number and not use that thread.
So which?
Do we need the audio?
Thread.
What thread was that, Mr. Atkins? What thread was that?
It was in,
The 5 October Mr. Sprinkles thread, it was when the person asked, he says, you have, I will find it and let you know.
It was one of those about, it was the one that I said was okay about the back and forth with the firearms, but Do we need the audio?
No, Your Honor.
Okay,
No.
all right,
The audio, Your Honor.
all right, next.
So did I hear that right? They're willing to swap out a thread where they're talking about the purchase and changing hands of guns to get this video where it's Lil Rod in the video holding two different firearms. It's dated 2 days before the Jamari Holmes shooting, 2019. Was that Jamari Holmes in 2019? They said 2019, right? Because it's a video and they don't care about the audio because it's just a song being played, but they want the optics of the video over a conversation talking about exchanging the weapons. Like, that's a little crazy to me. But I guess probably a good strategy when you have such a long trial, and something that's visual might be easier to remember all the way through to deliberations as opposed to reading words on a page. So, I don't know. What do you guys think? I think the conversation was a bit more incriminating, but I guess they hope the jury says, oh my god, gun in video, big scary.
No sound, Rudy gang. Around. Like block line. Ladies that thought like a stop sign. There's a whole lot of.
Oh my god. He looks like the character from Recess.
So, Your Honor, the state initially flagged this because we had referenced that Instagram post that says Rudy Gang, and his shoes and his comment is in similar reference to that of someone who had passed away. And so the state intended to introduce this just to show referencing that. Understand the court has previously admitted the photograph where he says that. So I understand if the court views this, would not want us to play this, but that's why the state intended to use this video.
Okay, so I
Cumulative.
would sustain
Spit out.
a cumulative objection. Okay. Next.
They kept the Spinelli video out.
I mean, honestly, it's clearer in the first one than it is here, I think. But yeah, whatever, y'all choose. Your case.
Which one is the state choosing?
We'll make that decision.
And let them know. Okay. Next.
I'm global, you know we're going worldwide. And we're going big on big, there's no lie. Better work your move, cause I'm about to work my move. Slap with a dude, now bitch that what he do. Yeah, I'm on the block, twin service.
We do.
And Your Honor,
Go ahead.
the state was using this for the gang hand signs. Yes, Your Honor.
Okay, so y'all already got that.
Understood,
You
Your
can
Honor.
Pick between the two, but only one of them.
So we'll take this one.
Yes, Your Honor.
Next. Mr. Schardt, y'all seem to be having more fun back there than we are.
We're just reviewing some surveillance, so we're ready when it's our turn.
Okay.
You always have fun.
20 cent rich air block. You know, on Rudy Soul, I'm gonna pop. Cause I'm about to work my move. That's what I do. They look like Rudy.
This is not the Spinelli I want.
Your Honor.
The state, given the court's prior ruling, and we will.
It's going to withdraw.
Yes, Your Honor. Yes, Your Honor. So I wanted to, those are the videos the state intends to introduce.
All right. All right, what's the next thing we move to?
Judge, we have many of the other witnesses. There are video interviews of some of the witnesses involved in the portion about Mr. Ryan. The state's contention, or I'm sorry, their plan is to use them only if needed as impeachment.
Okay.
We had asked the state, well, what redactions do you see that just blatantly this is not admissible?
Right.
They wanted us to, again, be the ones to go through and say which parts should be out.
Okay, y'all, I asked y'all weeks ago to get together on this, and that means at some point somebody needs to be the first one to say, well, how about this, or how about that?
And Your Honor, Ms. Abbasi and I.
You do it, you do it. Come on, y'all.
And Ms. Abbasi and I talked about this. She asked about the videos. I said, we don't believe that.
Where are we on it?
I told her that there's only one particular part in Mr. Mitchell, and it's when Mr. Mitchell's stepfather is talking to him about life. And I said, I don't think that that is proper. I said, if there's anything else, just let us know. If there's something specific that you are thinking of. And what her response to me was, okay, I will look at it and let you know. And she has not responded back to let us know.
And, well, I could go through the ones that I have. The hard part on it is I have just timestamps. We don't have transcripts of this.
If she gives us a timestamp, we
We'll look at the timestamps and either agree or disagree. We haven't
This
received
was supposed to be the day to do this.
Okay. Well, I can go through the ones that I have marked.
we don't have.
And y'all were supposed to have gotten together on it beforehand, and the y'all at this point is not just the state,
Yes.
it's also the defense. Okay, is there something else we can do?
We need
I
a
think that is
counter.
everything for
Okay,
Mr.
well, How
Ryan.
about one person over here on the state side, get together with one person over here with Mr. Ryan right now, and go outside and do that, and we'll pick up with something else.
We need a counter
I don't care
for
which one
Whitaker
it is.
saying, can we do
One of you
something else?
guys Work on this, and the other one stay here, and we'll do other things.
Here's my notes of what I think should be out.
I don't know how long this break is. Let's see. I got the court audio off.
Has this state, and I won't be surprised if the answer is no, but have y'all had an opportunity yet to formulate whatever response you're going to give to the three motions in limine that we just got this morning from Mr. Steele?
We had during the break, we focused on Mr. Ryan.
That's fine. I mean, I know. I didn't get a chance to get around to that either. We've all been working hard on other things. So, all right. What's next then? Are you ready, Mr. Schardt, on whatever it is that y'all were?
So, Ms. Hylton was kind enough to send a sheet with different body cam and videos that they sought to use.
Yes.
And I have reviewed them, and I'm ready to discuss them. The only, on some of the videos, obviously affects everyone, but these videos are involving Mr. Stillwell and Mr. Nichols and the arrest of Mr. Stillwell and Mr. Nichols.
Mm-hmm.
I know that Mr. Harvey had indicated that he had some objections.
I know Mr. Harvey was supposed to be here today, so.
So and I'm not trying to draw the ire of the court or Mr. Harvey. I'm just saying that I'm prepared to discuss the matters, but I am not speaking on behalf of Mr. Harvey.
Okay, well, sorry. Who is representing Mr. Nichols' interests today?
I am, Your Honor, Lamar Gartner.
Gardner?
Gartner.
With a G?
Yes.
Okay.
Mr. Harvey is actually in federal court this morning at a funeral this afternoon.
What, federal court this morning and a funeral this afternoon, is that what you said?
Yes, Your Honor.
Well, he didn't ask to be excused, which is fine as long as there's somebody here, but are you ready to proceed on these body cams?
I'm not, Your Honor.
Well, I mean, y'all may just not get the chance to do it then. Because we had plenty of advance notice that what today was going to cover. All right, so let's go. Why is somebody from each table not leaving?
I was waiting. I can go out first.
I don't care which of you goes, but. All right, what link or whatever should I be looking at for this tranche?
I go off the discovery as the so I think Mr. Atkins could better answer what Dropbox this stuff is in. But, just to take a
Couple things off the table.
Yeah.
The state has indicated that they plan to use surveillance video from the FedEx. Well, okay, I'll start with the BP. From the BP, which shows Mr. Drinks and other individuals shortly before the shooting on Windsor Street.
Okay.
It's surveillance video. There's nothing misleading about it, so I don't have any objection to that. It just kind of is what it is. It shows the surveillance of that store. There's also surveillance from the liquor store, which is an adjoining building to the BP. Don't have any issue with that.
Okay.
There's surveillance from the FedEx building on Windsor Street, don't have any issue with that.
Are these all
And
short?
they're all short, and I don't have any objection to them, and there's no audio on any of them either. So once we take those off the table, we have a video from the helicopter, APD Phoenix video. Now the video, Ms. Hylton identified as helicopter camera.ts. When I found it in my discovery, it didn't quite say that, but I'm fairly certain we're talking about the same video. It's what we've deemed the slow speed chase of the white Audi. Is that correct? That's the helicopter video we're talking about?
Yes, Your Honor. And to answer, of course, an original question, if we go to the witness 53 to 100 Dropbox, these videos are contained within certain witnesses to make easy so we all know what we're referencing. And then I thought I had copied the court, but I will forward to Ms.
And you probably did.
And I'm looking, I may not
so
have.
many emails.
I will forward to Ms. Percival now. I had sent defense counsel a chart essentially with relevant timestamps and the videos, and so I'll forward that so we can kind of go along so you can see.
Great.
So I'll forward that now.
All right, so let me.
And I don't think I sent it to the court because it was 2 o'clock in the evening.
Okay, so I've got 51 through whatever it is, 103 up. So you'll just have to tell me which folder within each of them.
So this specific video that Mr. Schardt is speaking of should be in Sergeant Newman's folder.
Do you know the number, the folder number? I have them in here by, I mean,
He will be towards the end, and Sergeant Newman is folder 83.
okay. Oh, apparently it has to download, which might take forever, so.
I can share the video.
Oh, no, here it is.
Ms. Hylton.
Okay, and is this, so there are 5 different clips?
So it'll be the helicopter_camera.ts.
None of them are labeled that. It's just helicopter camera.
And I'm sorry, I don't know why it says, if you go, are you in the Sergeant Newman folder? If you, does it open up and say Phoenix Helicopter Officer Matt Peterson?
Yes.
Once you
and
open
then
that folder?
within there's clip 41516171 and then one that's not labeled.
Well, on mine it says helicopter_camera.ts, so it should be.
Okay, well, there's no .ts, but, I file type TS. Okay, so that's the one I need to be looking at.
Yes, ma'am.
I'm clicking and nothing is happening. There it goes. Okay.
Mr. Atkins originally sent
This Dropbox link on August 30th, and then I resent it on September 12th.
Well, so far all it's doing is making me dizzy.
Oh, you were able to open it?
Yeah, I'm watching it. I mean, it's helicopter view. I feel like I'm in a video game right now. Does it get to something relevant at some point?
It does. It
Okay.
begins
When you play it at trial, assuming that it is ruled in, can we skip the part where they're just flying above the city?
Well,
I mean, they might be looking.
Okay, so I appreciate that after Whitaker just like threw some wrath over at the defense's direction, really in Bruce Harvey's direction while he's not even there. She really threw it in Lamar Gartner's direction indirectly at Harvey. I appreciate that she's still pissed off enough to say, can we just prune this down? It's so cumulative. Can we not play all this extra footage? So at least after that lash out, which I think was a bit unfair, especially if we find out that Bruce Harvey did give notice. I appreciate that there's some fallout trickling in that's helping us prune down these long pieces of video footage.
Looking for something, but they certainly haven't found anything yet.
They're just trying to orient themselves to the location. So when you're listening, they're on the traffic.
Oh, am I supposed to be hearing something?
Yes. There should be some audio.
Well.
Excuse me, Your Honor, we have to step out for just a minute.
Okay. Am I supposed to be hearing something?
You should be. And I can publish it so you can hear, or?
Why don't you? Because I'm not hearing anything.
And I don't know if I don't know if we need to watch the entire video, so I don't know what Mr. Schart's objection is, because we might be able to get to that point.
Okay, so with that video.
Hang on, is this a 12-minute video?
It is, but it captures the entirety.
Or more than that? 13 minutes and 40 seconds. Okay, and what's the objection?
There are, my objection is.
I'm looking for the timestamp. I have it on a piece of paper here, but I think it's 10:05.
Okay.
The person in the helicopter says they or Shannon is armed, consider them armed and dangerous or armed and dangerous, and we don't think that is appropriate. Also, at the very end of the video, I think the state is of the belief that, I'll just say one of the two individuals threw a bag into a bush.
Okay.
And there's commentary from the helicopter pilot about a bag in the bush. Now, if I understand if the helicopter pilot saw it and he testifies that I saw someone wearing whatever throw a bag in the bush, then that's fine. But I don't think we need the commentary on the out-of-court commentary on top of the video. And that's at the very end.
Okay, so Army Nurse is saying, so this video that we're going to watch, pay attention to the police that finds the gun. First, he walks in front of the police car without a gun. Then we hear ruffling with the plastic inside the police car. And here, and you know, like, Schardt has gone through these exhibits, so he can see what's coming. He's already prompting the court to be looking for some basis for which he's going to raise this objection. And it sounds like Schardt doesn't want commentary from maybe this police officer that Army Nurse is referring to that's spoken out loud in this video footage to be admissible.
We had a.
So what part of this do you want to show?
Your Honor, this is an entire chase, so it starts.
So who's chasing who?
So the police, so this video, so to orient the court, is on March 17, 2022. This is 3 days after the Drinks homicide.
Okay.
One of the gang investigators is at the Chick-fil-A on Cleveland Avenue. This car is a suspect vehicle at this point.
Okay.
And
which is the white Audi?
The white Audi is a suspect vehicle. And while at the Chick-fil-A, the investigator's getting his lunch, maybe Mr. Stillwell, they're getting their food, and that begins a low-speed, high-speed chase. When the helicopters start going, Mr. Stillwell gets out of the parking lot. He does not get his food, and they go on a chase. He goes the wrong way up streets, and he eventually gets to a home where he runs into a yard. He throws his phone away. We're able to subsequently apprehend that phone. They throw this bag of drugs away that's seen from the helicopter. They throw a book bag away that's seen from the helicopter. That book bag is subsequently recovered. It has drugs inside of the book bag. And so this is evidence of that interaction.
Okay, so the Audi is at the Chick-fil-A, and then a law enforcement officer is at the Chick-fil-A?
An undercover law enforcement officer is
behind. And then does that car start following the Audi or just the helicopter?
The helicopter and other cars. We have a trooper that follows.
When does it start? And when do we start seeing
the chase begins?
The Audi, this helicopter has been flying for 2 minutes and 16 seconds now.
Yes, Sharon, because.
All right, Phoenix, we got our mapping system up. We can.
If you listen to the radio, what the officer who sees the car, he's giving Phoenix information. Here, he's giving.
Phoenix being the helicopter from the outset.
From the outset. So what happens is the reason why the helicopter is orienting himself. The helicopter was at the airport, which is where it's at.
Okay.
And they are.
So the part before it gets to the Chick-fil-A, do we need that?
We can start it at the Chick-fil-A because that is the relevant portion and play it into.
And that's at minute what? 2-ish?
It's about probably where I am at 1 minute and 15 seconds.
Well, actually, yeah, about a minute. It looks like maybe that's
Yes, because what it's showing is that they're focusing on finding the target vehicle and getting ready to be able to assist the officers on the ground with where the car is going.
Okay, and then how long does this, it's not I mean, y'all are saying a slow speed chase. It's cars following the Audi. And how long does that go on?
The 13 minutes, that is the entire.
Do we need 13 minutes of that? Or can it
Yes,
just
'cause you
be
see
at
different-
minute 1, they start following, and then here's when something actually happens?
Your Honor, let me reevaluate that. I think that
Okay.
the entirety is
'Cause, I mean,
important.
honestly.
Of what happens in this entire interaction, we will look at it and get back to court, but we believe that the entire thing is relevant. At 10:05.
Well, they might be relevant, but it might also be a waste of time
You're right, and we will
to
look at
watch cars kind of just following each other down roads for.
Mr. Stillwell goes in the opposite side of traffic. There's a number of different things that
Well,
occur.
then pick out those parts and show those and condense it. Okay?
Yes.
Okay, so get back to us with a much condensed version of this.
So, in Your Honor, I agree with the court that a lot of this seems to be unnecessary to the extent that you're
Oh,
saying.
do you want all 13 minutes in?
I don't, but the reason I'm not jumping up and down about it is
Well,
there's nothing egregious that my
that's fine,
client
but
does.
we've got to find some places to cut some time. And if there's nothing being shown other than the cars driving down the highway, I get if they're taking evasive action, fine, show that. But the stuff that's just, we're driving, we can just skip that and get to the points that are more relevant.
Okay.
And so, Your Honor, to the extent that whatever the video that's played, I do want to discuss the audio briefly. I know,
All right.
I feel
So
like
I agree that he's considered armed and dangerous, needs to be
and
redacted. What else?
that's from 10:05 to 10:10.
Okay.
And then from 12:35 to 12:40, there's a commentary about the throwing of the bag. Again, I
Is-
get it.
Is the helicopter pilot going to testify?
Yes.
Okay.
And so, and I believe I thought we litigated that portion of it previously, but maybe it was just the drugs in the bag.
All right, so you'll redact that and he'll just testify to it, or it'll be on here and he won't testify to it?
It'll be
One
on
or
here,
the
he
other.
won't testify to it.
Now, I will say,
Okay.
because I'm trying to protect my colleagues' interests as well, Mr. Harvey, in our discussions, his stance is that none of the audio should come in because it just doesn't serve any purpose.
Okay, and what would the purpose of the audio be?
Your Honor, so in the audio, the Phoenix sergeant or the sergeant piloting the plane is telling the individuals where to go, how to find where essentially the cars are because they're behind. So
Right.
that is the
Okay.
purpose of the audio, Your Honor.
But, I mean, we can see from the video that they are able to follow, so, I mean, you can ask him, and were you?
I wasn't planning on having him narrate through while he was on the stand, so I was just going to have him play the video and as opposed to having him narrate.
Okay, why does it matter if the helicopter sergeant was the one who was able to direct, oh, he's turning left or whatever? Is it just things like that?
It is.
Okay, that's unnecessary. And he could just say in one sentence, I had a great vantage point, an eagle eye view, and I was able to direct them if you want him to say something like that.
Okay.
All right, what else?
So there is
a video of, I believe it's dash cam of Trooper Mark Campbell. I cannot get that. Mark Campbell, Trooper Campbell, my understanding is the person who located a firearm that the state is attributing to my client and Mr. Nichols. And I've seen this video, but I can't get it to play on my computer.
Okay.
I don't think it's that long.
The
I was
tech
wondering if we
issues.
could just play that in court and just
Okay.
all be on the same page.
I told Mr. Schardt last night I was having difficulty getting it played as well, so I may need to go back to the
Where
back
we
to the
pulled it
trooper
from
where we got
originally.
it to figure out why we can't play it anymore, because I was having some difficulty as well.
All right,
But
so y'all tag that as something we need to circle back to, please. What would we be labeling that? This is who?
That is Trooper Campbell's.
Okay, Campbell.
Yes, and it's in
All
his
right.
folder.
Do you want me to see if it'll, do you know what number Mr. or Trooper Campbell is?
Yes, he is 82.
Okay. And is it the one that's, no, there's one that's East Point Photos. It's the other thing that's not that?
It should be the different, I'm sorry.
Pursuit? Is it Pursuit?
No. That, not that 82. There's another 82 that says Corp Mark Campbell.
More than one 82. Yeah, Corporal Mark Campbell.
And then the next one says GSP Trooper M. Campbell.
Okay, GSP Trooper M. Campbell, and then
Pursuit.
within there is Pursuit, and then within there is the one that's video player?
So the video player and the other folder, it
go
appears that it
together.
goes to
Okay.
an internet-based system, so we need to just figure out how to get it again.
God, that sounded like an elephant. You guys earlier were like, is there a dog? That sounded like an elephant was in the courtroom. What is happening? Oh my goodness. And also big shout out here to Factual Lie. I thought I had this up on the screen, but the reminder here to hit the like button, you guys. It is free 99.
We'll come back to that one.
Oh, and I agree, Pink Slime. Like when I've made public records requests for body cam footage, there's something with the encoder, and there's a program called VLC that I have to use to fix the problem. I use a lot of other video software for different work for clients, and the only one that will ever open certain files is VLC. So shout out to VLC. It's like a free open source software out there. But I don't know if Pink Slime, if that is what you use as well, but it's like the simplest program ever. And all these other expensive programs don't know what to do with certain file types. But VLC just comes in like, we gotcha. We gotcha. Heck yeah, Ike, VLC plays everything. And then also shout out to Steph JK. Shout out to Kat for our sweet gang with the green heart. Love you guys. Big thank you to Steph. Again, Steph was out here, we're calling it sprinkling today. We are sprinkling in these memberships. We are taking back the word sprinkle from Michael Sprinkle. Nameless here. I saw you somewhere yesterday. I saw the fan picture. I said, oh my god, it's Nameless. So thank you, Nameless, for the 5. And then Muckduck Inc. Drop in 10 gifts in the chat. You guys, you know what to do. Make sure you say thank you if you got a membership. I see Muckduck is also giving VLC a shout out. Totally recommend it, you guys. Good thing your pretty says VLC opens everything. VLC has been dope for decades. Love to see it. I always love a good free open source software that stays free, stays reliable, doesn't get discontinued. It really has been around for a long time. And then Elizabeth Wright coming in here with another sprinkle / snipe here. Thank you so much, Elizabeth. Love it. Yes, VLC. That's it, Nancelot. VLC. And I think the icon is like a little traffic cone. So that's what you should look for. And thank you again for the gifted memberships. I totally understand the issue with them not being able to open certain files. Weird thing for... Hopefully Whitaker doesn't take a huge issue with it, because Whitaker has issues opening stuff all the time too. But who knows?
So what now? What's
the last one in this area, and this is my fault because I did not remember that Mr. Atkins sent this email. I couldn't find it in the discovery to Detective Grimsley. It's 5 minutes long. I can either, now that I see it in this Dropbox, I can either step outside and just spend 5 minutes to review it, or if we wanted to just watch it in court, either way, and then I can just...
Where would I find it?
It's in that same Dropbox. It's Detective Grimsley,
Okay.
and it's a longer video, but the state is only seeking to admit, I think, the first 5 minutes. Is that correct?
Yes,
All right, there's a whole lot in the Grimsley file, so,
I can play the video, Your Honor.
or just tell me.
So it's a VidCam video, Your Honor, and what's those 5 minutes are, this is a Vid camera that
All right,
is.
maybe just play it, because I'm not seeing something that's obviously.
It's just a lot of
labeled.
numbers, it's 7512. So in his folder should be a folder that says photos.
Yeah.
And then the second video, which is the MP4.
I don't,
You don't see
I don't see it, so can you just play it for all of us?
Yes.
We're gonna go to normal speed for the video.
And what's this going to be showing?
And like I said, I think it's probably simpler for me to just talk because there's no sound.
Okay.
But in this portion of the video, Your Honor, when you're looking from here, you cannot see it. But if you look to the far left of the screen, that's the BP gas station.
Yeah.
Where Mr. Drinks was prior to his homicide.
Okay.
And Detective Grimsley has the ability, even from this distance, I know it seems interesting, but he was able to see the specific times in which Mr. Drinks' vehicle, the Audi, and the other vehicle leave the gas station initially from the distance. This is something that may or may not come in, but that's what the purpose of those 5 minutes are.
Okay.
And then from here, what the testimony will be is
Timestamps, the time
Detective
frame?
Hogan saw this video first. And because of this video, that is why he went down to the BP to actually get the actual surveillance video from the BP gas station and the other 3 locations, Your Honor. So that's
So the purpose of this video is to say that
this
the
was,
detective saw this and it led him to want to go get more video?
and that's all. And again, these are just, we put items in here where, that's what this video is.
I'm trying to understand. So
what I think what Schardt's trying to understand is that this is what Love does. Love thinks that she needs to spell out every step that led to a piece of an investigation, rather than just say, hey, we followed a lead to the BP gas station and got the surveillance footage, and then discuss the contents of that footage. So I think that's why the whole courtroom's confused, and Hylton's following her lead, her boss.
Detective Grimsley, off of that video, and Ms. Hylton, I'm not coming at you. I'm trying to understand. Detective Grimsley on this video is able to look in the upper corner and see the cars leaving?
I mean, you can see cars coming and going. I don't doubt that. But I mean, if the only purpose of it is.
But he's able to, and you can call him and question because we talked about it as to how and why he's able to do that. But he is able to, yes.
Okay. Well, I mean, just ask him those 2 questions, and if you even need to. Why do we need to get to what it is that he ultimately saw on a better?
We are ultimately talking about the investigation because one of the defenses that some of the investigation has not been the best. So this is just all the steps that APD took in the initial part of this.
Hold on. If that's the reason you want this in, I feel like the jury needs to know that that's the reason you want it in. We want all of this in because the investigation wasn't all that good. All right, well, I think let me put that in my arsenal of things I can use on cross-exam. Like, this is... At least Hylton said it.
Homicide in order to solve it. And so this was one of the steps, the investigative steps that they took in order to solve this homicide.
I don't think that we need to be worried about that. So let's.
Well, the state has the burden, so we have to worry about those things,
Okay,
Your
well,
Honor,
then
but
I am going to rule that it is a waste of time under 403.
And honestly, it would really be to re-bolster a botched investigation.
And then if the defense wants to question, well, how did you know to go to the BP video and get that? Then you can play it. But otherwise, no. Next.
That, unless I'm wrong, Ms. Hylton, I believe that concludes all of the body cam video regarding the drinks case. Is that?
Okay.
Yes.
All right, super.
It was weird though. That really felt like Love embodied, like Hylton was a surrogate for Love in that moment, and Hylton just made an Adriane Love argument to bring in every piece of something ever. And I'm agreeing with you guys in the chat. Muck Duck lays it out and says, how is any of this relevant? It's just more time wasting. They have no case. And one of my favorite phrases, I use it all the time, they're just throwing anything they can to the wall and see what sticks. The spaghetti method. Like, is it done yet? Are we ready? Is it good enough? Just throw the spaghetti and see if it sticks. Like, that really felt like a Love moment, even though she's not in the room today. Like, and then a factual lie. Earlier you said something where Hylton had a Love moment. Did you mean that, or is there going to be like a buffer moment? Oh man. Definitely glad we're rewatching this, because that was just interesting to see Hylton say, and if it was Love never would have said that part about our investigation wasn't so good. We only got that because it was Hylton. Oh my goodness. There we go. Okay, shout out to Factual Lie who said, yeah, Hylton has a Love moment. Yep, I definitely see it. You were right. Oh my goodness. I'm gonna call that Hylton's Love moment in my timestamp.
All right, Ms. Hylton, what else do we need to still consider the admissibility of? Have we covered everything?
I think so. The only other things that I can think of, and I need to get Mr. Atkins, is the follow-up questions we had from the wiretap. I think we had those 3 or 4 audios we had to revisit today.
Right.
I believe, and if I didn't, I will. I did edit the demonstrative that we talked about regarding the phone records, and I sent that. I believe I sent it, and I'll just double check that I actually sent it, but if not, I will, regarding the text messages that we discussed on Wednesday, I think, with the Verizon text messages and the color of the Verizon text messages, what the demonstrative would look like. I believe I said I'm going to double check.
Okay.
If not, I will get that to defense counsel.
Okay.
I believe that, yeah.
Your Honor?
Yes.
There's also some of the arrest at Mr. Williams' home on May 9, 2022. There are 3 drone that the video, I don't believe audio, that the prosecution wishes to introduce.
All right, and is there objection to them?
Yes.
This was this the one that y'all had sent the email at the end of the day about?
Yes.
All right, I thought y'all were saying like they're not particularly prejudicial, but they're also not particularly probative. And I actually took from that y'all didn't care, but are you making an objection?
Yes. I mean,
Okay.
unless we have the wrong times or something, it would be a 403. It's just
And we're,
nothing.
I'm sorry, I didn't mean to touch you.
Sorry. There's nothing there. It's a
Okay.
drone sitting and looking at a
Very
couch.
little probativity. Okay.
And there are certain portions of that drone video, so we'll look at it, we'll consolidate it, and we'll send it back over to defense, what we plan on using, and see if there's still an objection.
Okay. Does that work? Did they try to shorten it to whatever might be relevant?
It works just fine, but why make us watch 45 minutes of video where
I don't
one
know.
of the videos was 15 minutes of a drone sitting on the floor, but we had to watch the whole thing to make sure there wasn't anything else there. I would just ask for more I mean, they've been great, but more consideration in the future on that.
Can y'all try to think through? I mean, it should come as no surprise that both the defense and the court would prefer, and I'm not doing it because the defense prefers it. The court would prefer it for these poor jurors who've been here for 9 months already, that things be as streamlined and concise as possible.
That is the plan, Your Honor.
Okay, and I know that y'all's universe of evidence is almost boundless, but try to do the best you can to, before we're in court trying to evaluate admissibility, have gotten it already down to what you think is actually relevant?
Yes, Your Honor.
Okay, all right, they'll get back to you on that, and then y'all can let me know if there continues to be an objection, in which case I will look at the smaller window of video and rule on it.
Thank you, Your Honor.
Okay. All right, so, I don't know if that's, Mr. Schardt, I had a note that said Stillwell cell phone search. Is that something we have yet to deal with?
You're right, we have not dealt with it.
Yeah, sadly, the search and seizure aspect of it has been litigated. and
Okay.
I did not win those arguments.
Okay.
But the contents that the state is seeking to admit, I'm still waiting on the specific pictures, texts, whatever they plan on using for my client's phone.
Y'all don't have that yet.
I have the
You
contents of
have
the phone.
the entirety of it. You don't have what they've narrowed it down to.
Correct.
Have y'all narrowed it down?
We have, a few other colleagues are working on that.
What are the sound effects going on in the courtroom today? Like, what happened?
So we'll be able to get that to Mr. Schardt by next week, Your Honor.
Okay, so I don't yet know when our next non-jury days are going to be. And I mean, hopefully we have enough to carry us through 5 to 5, but if we don't, it's going to greatly perturb.
Okay, so there you go. Sounds like tomorrow we'll have the jury present. So
The court that has not been provided in a more narrow form yet.
I will reach out to the individuals who are working on that right now, Your Honor.
Okay, do that. All right, so there were a couple of things that we had looked at yesterday, but then we're going to come back to. So maybe we can come back to them. And I'll give you a minute to send the message.
Thank you,
Since I know you're the only person for the state in here right now.
is someone blowing their nose? Man, if Hilton's wearing an earpiece, she has the perfect hair to hide it. Just sits right over her ears.
I'm ready.
Okay.
One of those, I'm ready, Your Honor.
Good, okay. So y'all were going to look and see whether, or the gun that, let me start over. On witness Mary Furlow Lewis, or around there, Mr. Zachary's gun matched to these cases, and I had wanted casings, and I wanted to know if there was evidence that he had possession of that gun at the time that this September 30th shooting occurred.
Yes, Your Honor, Ms. Love was looking into it. I'm confirming now to see if she was able to get the information. So that's what I am waiting for now for a response.
Okay, I had, if y'all are going to call Tariq's sister, you need to get that information to the defense.
We are going to be, just want to confirm this one. We will not be presenting that incident.
No? Okay.
No.
What number is that?
Well, I mean, it was around witness number 44.
43 and 44.
43, 44. So does that mean, what won't you be presenting?
We're not presenting that incident at all.
Okay.
And the incident above that, 41 and 42, we won't be presenting at all.
All right. We've just saved ourselves 2 hours. Okay. On number 63, Officer Greer, there was a question about relevance of Huey having given 2 fake names before his real name.
Why is the lead attorney out here? This is not legal advice. He says, wipe your nose. He's trying to get everybody caught up. Good to see you, lead. I hope you are doing well today and every day.
And date of birth, and then I don't know why we were coming back to that, but.
Yes, Judge.
Why were we coming back to
Well,
that?
yeah, that was why we were coming back to that.
Okay.
So, Judge, Mr. Huey was arrested on the date that's indicated on this document.
Yeah.
There's an allegation that he gave these 2 fake names and then eventually admitted his real name.
Uh-huh.
So he's not charged with any of these allegations of giving a false name or anything of that nature as a count. It's not alleged as an overt act. We haven't heard any argument that it's somehow intrinsic. So I don't think that it should come in on a basis of relevance. I think that there is a 403 argument to be made with respect to prejudice, character, and there should be I'm arguing character as well. So relevance, 403, and character would be my bases for asking this court to exclude any mention of Mr. Huey having provided a fake name and then eventually gave his real name and date of birth.
All right, what's the state's response?
Yes, Your Honor, we believe that is very relevant. This is approximately 1 month after the armed robbery that Mr. Huey is alleged to have committed in April of 2019. And given that when he is stopped and asked initially what his name is, he tries to hide that information. The state decided not to charge him, but it is important that he decided to first not reveal who he was because there was a warrant out for his arrest, and hence he was arrested after he gave his name.
Okay.
So, Your Honor, my response would be that the state isn't able to establish that on this particular date that Mr. Huey knew that he had an armed robbery arrest warrant pending. So that would be totally speculative that he gave a false name because he had an armed robbery warrant. Unfortunately, sometimes people give false names for various reasons. Sometimes they just give a false name.
Yeah, but one of them could be consciousness of guilt. So I am going to admit that over objection. All right, so that takes care of that one.
Yeah, he tried. I think that was a stretch to try to get that
And-
excluded.
Let's see.
And thank you guys for dropping Lead's link in the chat. I saw Blue Eyed Hillbilly and Steph JK both dropped his link. It feels weird to say because my assumption, and I shouldn't assume, is that everybody already knows who the lead attorney is. If you haven't checked out Lead Attorney, hit that link, hit the subscribe button and the bell. Check something out next time he goes live. You'll see a ton of familiar faces in the chat. And I'm also going to pull up Good Thing Your Pretties Vouch. TLA is a great lawyer. I've watched a bunch. You will learn a bunch over there. And what I really love about Lead Attorney is his storytelling ability. So if there's something that needs to be explained, he's got a way to put it in not really even layman's terms, but like an experiential, like a real story to explain a concept or how something works in legalese in plain language. Just like an incredible skill / talent that he has. So always a ton of appreciation for the Lead Attorney. You guys show him so much love too. But again, if you don't know who Lead Attorney is, I'm shocked. I am very shocked. But his link is in the chat. Go over there, hit that subscribe button and that bell. Super, super awesome. And then, great question. Is Lead Attorney streaming in the morning? Let's see if he lets us know. Because, you know, I got to start late tomorrow. So, I know Classy Beats is going to probably do some YSL trial in the morning as part of his music morning show. But I know you guys get lost out there in these YouTube streets when I'll be gone for like 4 hours. I'll start late. And everyone's like, we don't want to go to Law and Crimes chat. Also, while we wait, let's see if Lead Attorney, are we streaming tomorrow? Okay, so on AV's channel. So let's get AV's link. Follow him anyway. But hold on now. And wait, will you be guesting? Like co-paneling? Co-hosting? And honestly, kind of the same spiel for AV. Very good at breaking things down. Okay, so this is AV's channel in the chat, dropping the link right now. And also just a super kind person all around. So Lead can be a little rough when he tells his stories. He tells it like it is. He's pretty blunt. AV is like the perfect balance to some of that. It's a great combination. Here we do TiVo time. That's Mondays every day. We do TiVo time. And then also in the meantime, thank you so much to Peter Ortiz who dropped 10 gifts. That's super awesome. And you guys always know, if you guys have been here and seen Peter Ortiz give a gift, it's awesome because not only can you say thank you, but you can use the explode emoji and just spam some explode emojis. It's an all-around good time. Love to see Peter Ortiz's commentary. He's also asking, can we bring a RICO against Fulton County? If only. We need like a rogue prosecutor to make that decision. Like someone just goes rogue and charges their own office. That would be a good time. I would watch. Thank you so much for all your support, Peter. Muckduck Inc. says, what is quite And I think maybe, I don't know how to parse the beginning words, but maybe what is quite interesting is Hylton has way more ethics than her boss. She has a career ahead of her, but Love is going to take her down. You're attached to this trial in one way or another. But I do really think, again, that moment we just saw like 10 minutes ago, we heard a Love-style argument from Hylton, but if it had actually been Love, Love never would have said that bit about, like, our investigation basically sucks. So Hylton at least gave us some honesty there. Had a little bit of humility there about why the case has to be presented, or she's trying to present her case in the manner they're trying to present it. Great point there, Muktuk. And then the beautiful Amy E is gifting 5 memberships. And that's since I'm going to defer to you, Amy, I'm not sure if you were here when I asked earlier. Does Monday's music show at night start at 9 p.m. or 8 p.m. Eastern? Because I think I had the time wrong. And you guys know I love it over at Club Classy, or Blub Lassie as we need to say. And I'm sure Steph has already shared the link, but in case that's not the case, this is Classy's link here. Thank you, 8 p.m. Eastern. Okay. And not only does he do a morning show where he's been talking about YSL stuff in the morning as well as other interesting events in the same space, but at night on Monday, Wednesdays, and Fridays at 8 p.m. Eastern. We're calling it Club Classy, but it's a music show where he showcases upcoming artists. It's really incredible, you guys. You're going to see a bunch of people in the chat shout it out. Everybody always has a good time, and you'll see like half the people chatting right now. You'll see them over there. It's really, really, really a good time. So hit that link, hit that subscribe and that bell, and just come hang out with us one of those nights over there. I missed it Wednesday and Friday, and it kind of felt lost. I felt out of place. And thank you so much, you guys. You guys keep rolling in with these supers. I'm like, we got to get through day 142, and this is a great problem to have. I appreciate you guys. HVAC for Dummies, one of my favorite profile pictures. Says, glad to see you're okay, Kat. We are back. We had a little internet hiccup today after service was restored, and I guess it wanted to go down one more time. But we are back. Thank you so much. Glad to see you. Thank you for checking in. And then Muktuk with the huge 50, holy moly, says, absolutely disgusting. The defense does their best improvised, valid reasons. Yet the judge responds on behalf of the state that it is consciousness of guilt. Utah State never said that. The state never said that themselves, so she's basically doing the job for them, as often is the case. What I do think, though, there's always some degree of judicial discretion, and I think that there's a certain parameter within which the judge will want to keep the record clean, and they really should do this for either party. But when it comes to something like consciousness of guilt, I do actually think that would be a correct reason for that piece of evidence to come in, and for the jury to be the determiner, to make the determination of fact there. However, like you're saying here, the state should be making that argument. It's clear that Hylton knew she had to fight for this piece of evidence to come in. She prepared for it. It wasn't an objection that, was made out of the blue. So Hylton should have been prepared to offer consciousness of guilt as her basis, at least one of them. So sometimes I don't know how we're 142 days into the trial and we're dealing with evidentiary rulings on something that Hylton prepared for, or really any of the prosecutors. It's not just Hylton. They don't come up with one of the key arguments that I, as a layperson on YouTube, I'm not a lawyer, would suggest. So I don't like to see the judge have to be the one to fight for it. Although, guys, there is a certain time and place where the judge does need to keep the record clean. And it's a good thing that they do. Because we don't want an issue after the trial's done where they're like, hey, this actually should have come in, But it is disappointing to see like the help, the assist, pretty much consistently go in one direction. And again, on the other side, if you want justice for victims, you should want the prosecution to be able to make these arguments and be able to get in the evidence that they need to present their case. So, yeah, a lot of really complicated feelings here, right? It's a gray area a little bit. Food for thought. Thank you so much, Muktuk. I love to go on my rants. And this is a super generous super chat. So thank you so much. And we're going to hit this play button, see what is in store next. I know a lot of you guys are waiting for that step up moment from Brian Steele, and I'm looking forward to that.
Number 68, Sergeant Henderson.
Yes, Your Honor, we were discussing what exactly he would testify to as it related to the and so the October 2020 armed robbery. As we stated yesterday, Sergeant Henderson not only investigated the October armed robbery, but he also investigated the April 2019 armed robbery involving Mr. Huey. As it relates to the October armed robbery, he will talk about Mr. Huey had a phone that day as well. He received consent to search that phone. The day that Sergeant Henderson interviewed Mr. Huey, he obtained his phone, was able to go inside of his phone. That phone we will be seeking to admit that cell phone into evidence and contents of that cell phone into evidence. And so those are some of the items that he will testify to. I think the question is, what else would he testify to besides speaking with Mr. Holloman? So those are just some of the other items that he will be testifying to as it relates to the incident that occurred in October of 2020.
Hold on, I forgot about this new and awesome part of Club Classy, the music show, Classy B's music show. Amy E., I heard you guys announce it last week and then totally forgot because I don't think I've really seen it in action just yet. But they now do a raffle for the audience members. They give away money and prizes to the artists that are performing. But now they've also introduced a raffle for a $100 prize for people like me, people like Steph JK that are in there listening to the artists and hanging out. So, second reason there to tune in to either Monday, Wednesday, and Friday over on Classy Beach channel. Thank you for the reminder. Sorry I forgot. It's like a big deal, and I'm just like, oop, out of mind.
So, Your Honor, in response, Sergeant Henderson interviewed Mr. Holloman, and the court has already excluded on the basis of confrontation clause and Mr. Holloman not being here with us. So an interview, photographic lineup process, that's all already been excluded and kept out. The other issue is that in the document here before us, the state is indicating that he's going to testify to, quote, similarities in an April 2019 robbery, and it says with Fleetwood. There's been no evidence that I'm aware of where Mr. Fleetwood was charged with an April 2019 armed robbery. So similarities and things of that nature, I think that's going to create a 404, maybe a 404B argument that we haven't received notice on. Not sure how this Fleetwood person is going to be injected into this discussion with Sergeant Henderson in terms of testimony. And they indicated they were 4 days apart. So I'm going to object on that on the grounds of relevance. There's been no proffer, no showing that a 4-day alleged armed robbery with Fleetwood is somehow similar. So I'm not clear what their basis is going to be for attempting to introduce some extraneous alleged armed robbery with a Mr. Fleetwood.
And when we say robbery with Mr. Fleetwood, do we mean Mr. Fleetwood participated as a co-perpetrator or Mr. Fleetwood was the victim?
So, Your Honor, Acts 85 and 86 and 87 are an April 22nd, 2019 armed robbery in which Javon Fleetwood is a defendant who is a YSL co-conspirator. In that April 22nd, 2019 armed robbery, Mr. Fleetwood is alleged to have robbed an individual in the Jonesboro South area. The way that Mr. Fleetwood gets to that armed robbery location is in a black Mustang. That black Mustang is what's going to be the relevant piece of information. Mr. Fleetwood gets out of that black Mustang, out of the passenger side of that vehicle, goes inside of a building, robs an individual, and steals his car. 4 days later, this armed robbery with Mr. Huey takes place, and the suspect vehicle in that armed robbery is a black Mustang. We have pictures of Mr. Fleetwood and Mr. Huey together on Instagram. We have pictures of that black Mustang that we believe is the same Mustang used in both incidents. So there's some similarities between the April 22nd, 2019 armed robbery, which is 3 of our overt acts order.
The April which?
They are 85, 86, and 87.
The April 22nd that Fleetwood is alleged to have perpetrated?
Yes, Your Honor.
Are overt acts?
85, 86, and 87.
Okay.
And these overt acts happened 4 days after that armed robbery.
Okay, can we ask IT to figure out why we are having sound issues again, or do you already know?
And by
We just
IT,
have
we mean
cheap
Miss
microphones.
Persefield.
Okay. Okay, so if these are overt acts, then y'all ought to, that are listed in the indictment, y'all ought to know about them.
So, Your Honor, with respect to how they are attempting to somehow link, I guess, a Fleetwood case with Mr. Huey in terms of similarities, what we haven't heard is that this particular Mustang, we don't have a tag number for this Mustang. We don't have an identity of anyone who is allegedly driving this Mustang on this date that this Fleetwood case allegedly took place on. We don't even have evidence of who is supposedly driving a Mustang with respect to this incident concerning Mr. Huey. We don't have a year, make, and a model. We don't have, what we have here is that, oh, we have a black Mustang, a Ford Mustang. I guess that's their connection of black Ford Mustang. And somehow that's supposed to link to two armed robberies on different dates.
Okay, so, and what? This officer will be saying, what? I was already investigating this other one, and I noticed that, are they both in the same area of town?
No.
No, so ironically.
So what are the, what would he be saying was similar?
Because when I say similarities, I mean the fact that Javon Fleetwood and Marquavious Huey are friends based upon Instagram, based upon that. So in the armed robbery on April 22nd, 2019, Mr. Fleetwood arrives
in a black Mustang and gets out of the passenger side of it to go perpetrate the armed robbery.
And then 4 days later, in the Buckhead community, a very similar black Mustang is involved in that armed robbery of Mr. Maynard.
And that Mr. Huey is...
And Mr. Huey is driving that
alleged to have been the driver?
No, he's alleged to have been the perpetrator of that armed robbery.
And did he get out of the passenger side? Or does anybody know?
It's not alleged.
We cannot tell from the surveillance video. What we know is the victim will say, I saw and heard a black Mustang. We believe an individual in a yellow jacket, we believe to be Mr. Huey, is in that area. Then we have Instagram posts of Mr. Huey in a black Mustang that he is saying that he has possession of. That is his Mustang. He has about 2 or 3 pictures of himself in this black Mustang, all in and around the time of these 2 incidents. So circumstantially, Your Honor, Mr. Huey was never charged in the April 22nd, 2019 armed robbery, but the fact that this black Mustang is involved in 2 armed robberies very close in time with 2 individuals who associate with each other is what those similarities are.
And Judge,
okay, but in 85, 86, and 87, y'all, the state is only asserting that Fleetwood did these things, right?
Correct, yes.
right. And then, Judge, if I could just respond to the court's initial question regarding where is it alleged that these perpetrators in the Buckhead armed robbery, according to the witnesses on scene, the alleged victims, they are claiming that 2 individuals, that there was a driver of this Mustang, and they indicated that 2 individuals got out of the back seat of this Mustang and began to. So to answer the court's question, there's no evidence or indication that Mr. Huey again, was at this Fleetwood alleged armed robbery. There's no indication that Mr. Huey was driving a Ford Mustang at this Buckhead alleged armed robbery. I think all we have here, Your Honor, is a black Ford Mustang that is alleged to have been involved in 2 armed robberies in 2 different parts of town. There's no evidence or indication that Mr. Huey was involved or part of a,
Okay, but there is Instagram from Mr. Huey's Instagram that shows him to be claiming ownership of a black Mustang?
Yes.
Well, there's Instagram photograph that shows Mr. Huey in a photograph with not only a black Ford Mustang, with an Infiniti, other vehicles. There is an Instagram photograph with Mr. Huey being in the same photograph with a Mustang. Yes, but there is no evidence that Mr. Huey owned a black Ford Mustang.
He was around, had access to.
But in terms of the connection,
so
I think it's tenuous.
This investigator is going to say what? Was he already investigating the April 22nd one?
Yes, he was assigned the April 22nd armed robbery, 2019. He was assigned the April 26th, 2019 armed robbery. And interestingly enough, he ended up investigating the October 1st, 2020 armed robbery. So he investigated all 3 armed
robberies. And so he's just going to say, so he's going to be testifying about both of those armed robberies at the same time?
Yes.
Okay. when he's on the stand.
Yes.
And he's going to say, a black Mustang was used in this one.
Yes.
And then he's going to say, a black Mustang was used in this one.
Yes.
That's it.
Okay. Well, I mean,
I don't
he can
see how
say
that's-
both of those things.
I don't see how that's, again, Your Honor, I just would argue for our purposes that the connection is not enough, and under
What do you mean is not enough? I mean, I don't think he's not going to say, so I think Huey was also involved in the Fleetwood armed robbery, is he? No. Okay, well then,
He's not going to say that. He
he's
can't
not going to say that.
Can't say it.
Correct.
Okay.
So does that wrap up the issues for this?
For us.
Okay.
Yes.
All right, so is there anything else about Henderson's potential testimony that we need to sort out now? Or that we can sort out now?
I think we're okay, Judge.
Okay, all right, so I will take that tab off as well. All right, and then next.
And Your Honor, I have a response to Ms. Mary Lewis.
Okay.
Your Honor, the state will
I
not
thought she was going to say Miss
introduce
Mary Mack.
that act unless and until we determine whether or not Mr. Zachary was in possession of that gun.
Okay.
Prior to the date of
All right, thank you.
Can you repeat that number again?
It was witness number 7, basically, or 6 and 7, I guess, unless they can confirm that Mr. Zachary was in possession of the gun
Understood.
prior to that September 30th, then they won't do that act. All right. The next thing we were going to circle back on was witness 71, which is Viverito. There had been some question about exactly the scope of the court's exclusion of a chase or parts of a chase or something about a chase. And I thought y'all were going to let me know either what trial day that occurred or what actual calendar date that occurred so I could go back and look. Did anybody get a chance to do that?
Well, we were searching, Your Honor, and there are a lot of days here, and we have not been able to track exactly what day that took place.
Your Honor, and we recall it, this court excluded, and we cut those witnesses. The court excluded Mr. Huey for the October 20th armed robbery was arrested a year later, and the court said that that was too remote in time for him to know that he was.
Yeah.
And so we cut those witnesses.
Okay.
I mean, investigative member Risa was not going to testify today.
Okay, because
Those witnesses are cut.
okay, so then Viverito is not going to be dealing with social media video of Huey showing people in jail the car he purchased, which is the same used in the high-speed chase?
If the social media video comes in, we will not talk about the fact that that was involved in the chase.
Okay, so for what other purpose would the social media video come in?
I need to look at it again and see if he is associating with anyone else, but outside of that, it wouldn't.
Okay, so this probably would not come in.
Thank you, Judge.
Okay. All right, so that was all we needed to circle back on those.
Your Honor.
Yes.
I did talk to the state yesterday concerning witness number 66.
Okay.
And I think the state indicated that they were going to take my basis for indicating how this particular information would come in. It says it was a jail call that we're talking about. If you look over in the right column, in the far right column.
Okay. Yes.
And if you look at what's indicated in the parentheses,
Uh-huh.
I had a conversation with the state concerning that fact and that they could not play that particular information through any other witness other than witness number 66. And they indicated they understand my basis for that evidentiary objection and they would consider that. Did I get that right, prosecutor?
All
Yes,
right.
Your Honor, we intend to introduce it through Ms. Stanley.
Okay, so we can cross out the parenthetical.
Yes.
Okay, thank you for bringing that to my attention.
Thank you.
So on each of these crime scene techs that are the planters people, well, and frankly, all of the crime scene techs from here on out, this jury's already heard lots of crime scene techs. And y'all have assured me that these people are going to take a very short amount of time.
The planters people, yes.
Yeah, so I just want to make sure that you do not plan to have a an entire, like, where have you worked throughout your entire life, and what's your education, and blah, 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 and what do crime scene techs do? And because they already know that what crime scene techs do, and frankly, all we really need to know is on whatever date I worked for APD or whoever it is, and I was a crime scene tech, and then move straight on to the condensed version in testimony about whatever it's showing.
Yes, Sharon, we got
Okay.
that in when we gave those times yesterday.
Super, thank you.
Love that request, to be honest, because that's always a drag. And then guys, especially if you tuned into the stream yesterday where Nick Starro jumped on the panel, there was a recommendation from Nick Starro to grab one of these power packs. And you can't see the coupon right now because I've already purchased and used it. But there was like a $350 off coupon on this. And I also saw you guys in the chat saying, you know, I have a Jackery as well. Love the thing. It's awesome. So thanks to the support of you guys, I now have backup power in the case of a future power outage, just like I dealt with Milton, that doesn't use loud, noisy diesel fuel generation. I am a renter. I have a homeowners association. They will not let us have a noisy generator. So you guys helped me find the solution. Really cool. Like, you guys are so awesome for that. But wanted to share with you what it was that I actually had grabbed. So yeah, it was like a super cute coupon. So this is the link to it there. And yeah, you're thinking like the full house generator that you can like plug in and it powers your whole house in an outage. Totally worth it. Totally worth it, I think, if you own. It makes no sense for me to put in because my landlord would end up owning it. But really appreciate you guys for the insight and advice. It's hard to pick and find a product when you don't know someone that's used it. It's hard to trust online reviews because people can get paid to leave the reviews. So not only has your support, like you guys, Nick said we're going to fund this generator. You donate $100, I'll take a shot. It was a fun stream last night. But also you guys helping recommend the product is a big, big help. So thank you to everybody. Big thank you to you guys.
All right, I'm going to look back through my notes to see what else we might have needed to still be circling back on. And y'all, unless y'all know of something already that we can do right now.
And I'm sorry, Ryan, I didn't mean to cut you off. We got the my colleagues were able to get the GSP video.
Okay.
We're about to double check, but if we need to circle back to the.
That 5 minutes? Okay, why don't we go ahead and watch that?
Judge, why don't you like to address the Overt Act basis?
What now?
Why don't you like to you want to know what can we address now? Why don't you like to address the state's position that they can use Overt Acts, which are not in the indictment, solely to support the conviction? When would you like to review
So
that?
unfortunately, I have not been able to read yet y'all's briefing on that, so not yet.
Yes, Your Honor.
Okay, but thank you. And you know that on the intrinsics, because you were involved in that,
Yes, I
that
am.
those have all been ruled on. Okay.
Thank you.
Your Honor, just to orient, this is that same chase that's on the helicopter but on the ground.
Okay.
And we can watch over.
Where?
Sorry, let me slow it down.
I don't know what the objection is, but
I think he couldn't see it, right? So he just wants to see it.
you want to see it now or just have him watch it?
Well, I mean, I hadn't seen it either, so you're just watching it now, right?
Yes.
Okay, so yeah, and it's, go ahead.
And we're playing, the state is seeking to play from beginning to when the gun is handed over, correct?
Correct, and based on the court's other ruling, something's maybe short, but we'll play to that portion
Okay.
now so the court can see it.
And do we need the sound? Yeah.
Where?
Y'all are gonna want this sound, right?
Where? Bill, what's that one?
Was there a warrant out at the time? So are these people trying to get to where the Audi is?
So what, a number of details come in to apprehend
Trying to get there. Yeah, I mean, is there an Audi in?
helicopters calling out of over radio.
Right. So these are officers who are like, oh, I can help with this chase. Let me get to this area.
Yes, so now he's directing them to where they are now.
Right. Okay. And so why would it be relevant?
We can get.
We're just watching it all now, but this part is not anything you're going to offer. Right? Okay. Can you skip to the part that? Okay.
Whitaker is like snapping her fingers.
Those GSP cars go fast. This is not a chase, but it's definitely high speed.
There was a gun back there. There was a gun in the street.
So this is what Schardt doesn't want in the commentary.
I'm gonna go back and get it.
Wait, hold on. We're all like, ooh, footage, cars, engine noises. Brad, I kind of agree. No skipping. We want this. We want to watch all the wee woo.
Boulder Way and Meadowlark. Meadowlark, the west Meadowlark. Meadowlark, running on foot.
And do we know whether this is the same route that the Audi took?
Yes, the Audi is, we know from the helicopter, this is the same route as the Audi.
Y'all get that gun? Huh? Did y'all get the gun? Through the fence to the right of the house, reveal. It was in the street.
The house where they're apprehended is on this street.
Hey, somebody get over to Ore Drive. Ore Drive, that's where it's at, where it comes out to. Where they're
Is
running.
this officer going to testify?
Tony, you out there? Did they give you an update?
Takes it and gives it to law enforcement. That gun is significant because.
Do we see the gun on the camera ever? Okay, let's skip to that part.
Numbers on Boulder Way was 24.
I do.
I don't know yet. Did they say they tossed the gun? But this is the gun.
Okay, so like, are we gonna end up like, does this guy not have body cam footage? I heard them say at the beginning of the hearing day today that there was a spreadsheet that Hylton turned over to the defense, and it has like the different body cam. Are we gonna get a body cam of this officer that just showed up with this bag with the gun? Because you don't really see that on screen. Like, Army Nurse, thank you for like cueing me and I'm sure others to tune in and like pay attention to the order of events here. But he's yelling the whole time, they threw a gun, they threw a gun. Presumably, if we take this at face value, he turned around and drove back here because he thought this is where it was thrown and goes off somewhere to pick it up. But hopefully we have body cam. And if nothing else, like, if we don't get the car, we don't really see who's in the car, do we?
They're on around the curve.
All right.
I don't know what they want me to do with this. Right there with it.
People who said, I saw a gun get tossed, or what?
No, we believe, and we just don't have this because they switched radios, but the first officer is an East Point officer who eventually, a police officer was able to get directly behind the Audi. That was Captain Glover from the East Point Police Department. He does not recall now, so we can't bring in, we believe on radio someone said they tossed a gun.
Okay,
However,
but y'all don't have that evidence, and he can no longer recall.
remember that. So what happens is by the time he gets around Trooper Campbell, he sees the gun in the middle of the road, he picks it up, he gives it to APD. That gun is eventually ran. It comes back to the girlfriend of Mr. Stillwell, Miss Alexander, and then that gun, there's a knifing hit to shell casings that are found on March 16th, 2022 that we confirm. So that's...
Okay. All right. Mr. Schardt?
I missed that last part. The knifing hit is...
Sure, so it appears on March... From the evidence we gathered from the shooting on March 16, 2022, where we believe individuals from the opposition gang shot at the house, there was returned fire. Some of the shell casings match this gun found in the middle of the street.
All right. And all right, having now seen the video, is there objection?
My objection is with the audio, the commentary. I mean, because it seems to me, I'm trying to place this together. I can't remember his rank, but Glover, my recollection of his testimony, and this is when we had the prior judge, he testified in some sort of, I think it was a motion to suppress. My recollection is he specifically said he personally did not see anyone throw anything from the car.
Okay.
Because he was the closest person. There seems to be some rumor, like Ms. Hylton was saying, that something was seen thrown out the car, but there's no identifiable source to that rumor.
Okay.
So to the extent that the audio includes discussions about who saw them throw this out the car, I would object to those discussions.
Okay, so I do think that last part where he walks up and is saying, hey, did anybody say that, needs to come out. But this officer says on the radio, I saw them toss a gun, or no, he didn't. I'm sorry. I see a gun on the street. I'm going to go back and get it. Are you objecting to that audio?
I believe he's testifying, so he could testify to such.
That is bold. Schardt is suggesting that out loud on this recording, on this footage, the officer is saying all of this out loud, so it'll be on the video footage later just for him to circular reference.
Okay. And what would the state's response be?
He is testifying, so we can ask him, or we can just say, is everything captured on the body cam video? We'll say yes.
Okay. That would be fine, but can we don't need all of that lead in beforehand where they're getting to the relevant place. So if you want to just, pick it up right before he sees that, and then it's fine to go back to here and show
Okay, I have a small problem with that because if you just start at the clip, the jury's going to they're going to be focused, they're going to see it right away. They're not really going to have the normal processing that I think as a fact finder they should have. I think they should actually play more of that clip. And maybe we'll hear the defense argue for that. But if you tune right into where someone starts saying, hey, I saw a gun in the road, you're going to assume that that's why we're watching this. It's probably the truth. But if you're watching that whole chase and you're like, what are we supposed to be paying attention to as a person? By the time you get to these relevant parts, you might be like, I don't really believe that somebody would notice something like that. I have questions. So I don't know. Let's see if the defense argues back against that.
And get it in, have it in the bag. Okay, so a shortened version with that last part of the conversation redacted. Okay. So we have still not sorted out that one wiretap that was the 2119, and so we waited for Mr. Harvey to get here, but
here we go.
Mr. Harvey is not here, and we need to figure this out. So, and I mean, everybody briefed it, or Mr. Harvey briefed it, and I think the state briefed it.
Your Honor, and Ms. Love was handling that. I don't think we briefed it.
Well,
she was doing the research for it. This is the hearsay with the hearsay one?
Well, maybe not briefed, but sent case law or whatever. Y'all had plenty of time to send submissions, and some people did. I really can't remember who all did, but does anybody want to say anything else about this?
Your Honor, I do know that we were waiting on the state to file a response to our motion. I'm sorry.
I don't think so.
Shout out to Kitty with the throwback to the Acorn cop shooting. That was crazy.
I believe our last discussion was we were waiting on Mr. Harvey's return.
Mr. Harvey's version of the conversation?
No, wait for him to return to argue. That was still.
Yeah, well, he's not here. And he was supposed to be here. And there's an attorney here for Mr. Nichols who says he's not prepared to argue it, but I'm prepared to decide it. So if somebody wants to argue in Mr. Harvey's place, have at it.
Right, so we are going to get Steele up at the plate. But before we do that, before we get off topic, you guys had some commentary for what we were just talking about. Thank you, Michelle, for the $9.99. I think the judge knows the state wants a mistrial, so Fani can use a mistrial in her political campaign. She will be able to say, see, I tried to prosecute gangs. A win for Fani would be a mistrial. And this is interesting, and I think it's actually a good point. Because in my head, I'm like, oh, a win, it'll be like victory, we were tough on crime. But after going back recently and watching, we're trying to be tough on crime, but you guys aren't giving us the funding. You guys aren't giving us the stretch, the prosecutorial power that we need to be able to prosecute the way we need to prosecute. So that same line of argument, I think, fits the puzzle piece. I think what you're saying here is another puzzle piece that fits nicely with the way Fani orates and gives speeches about her platform. I think this is a really good point, Michelle. And I didn't think of it that way until you said this. So shout out to you. I love thinking about things in a new way. Appreciate you. Peter Ortiz had me cracking up there. I just wiped my nose for you, Cat. So you guys all secretly, if we all wipe our nose at the same time, we can dismantle the RICO statute. Butterfly Lover, this was super sweet. I enjoy watching your lives. You're such a humble person and you deserve all good things. This is so nice. This is an aspiration and a goal of doing this. Never expected to have a YouTube channel, be the one on screen, but it's really nice that it makes you guys happy, like that there's meaning to it. So thank you so much for those kind words. And then back to this subject before we move on to Steele stepping up to the plate here. Black Butterfly says the gun is a setup. What do you guys think? Like, to me, my skepticism comes from a place of this wouldn't be the first time a police officer did something dirty, framed somebody. Like, wasn't there something recently, I think it was like in Michigan, some guy, they said he was like drinking and driving or something, and they ended up putting like little bottles of alcohol in his car, like to frame the guy. Like, it would be far from the first time. So I have a skepticism from outside of this specific trial. So when you see someone walk onto the camera frame that somehow saw a gun while they were driving and chasing somebody on a kind of winding, narrow road without shoulders, which I would think you'd be pretty focused on where you're driving and not really be able to discern what looks like a handgun, which is small, pretty small. And you're moving at a certain speed where, in my opinion, if you can even see it in your peripheral at all, you might not be able to distinguish what exactly that object is laying there. So to come from off the screen, suddenly with it in an evidence bag, if the defense cross-examines and asks questions that elicit that type of image of something happening, I would be primed. This is probably why I wouldn't be sat on a jury, because I already have a high degree of skepticism. I'd be like, I could see why that would be a setup. I believe police set people up. They would boot me so quick during voir dire, I'd be gone. But I think it's a great question. Casper says, I saw a tree branch on the road, which is, I think, even if there was a gun and I drove by it, my brain, especially after we just had Milton pass through, I'd be like, debris. It's debris on the road. Bees on Mars says, I'm completely skeptical. And the thing is, it could be true that there was a real firearm sitting there. But that's a difficult argument to make, to me, just because of my skepticism. And then, yeah, Nancelot says you can't even see the car. Crystal says, I didn't see a gun. There's something, but I didn't see a gun. Survivor Speaks, good to see ya. Says, I think the POW is a setup. Like, and then, yeah, Blue-Eyed Hillbilly, good point. No gloves while collecting evidence. I'm sure we're gonna hear that argument. But it's interesting that they have to work around who they're calling to introduce this through, because the other officer from East Point was just like, I don't remember. Like, shout out to that officer for keeping it real, but like, or maybe it was a lie. Maybe he does remember and doesn't want to testify. Either way. I don't know. I don't know. The evidence bag came out fast. Peter Ortiz with another great point. Thanks for the 2. Says no body cam or gloves were used. And Crystal, I see you still have a wrench. So you still have it. I think YouTube's being funky. I don't know. But you definitely still have a wrench. I don't know. It's a big question. Bees on Mars says no visual confirmation, and now one of the cops doesn't recall. See, this is a mess. Raina, yep, cops are allowed to lie. Like, and we've kind of seen that over and over through several of the, not just APD officers, but also the detectives that qualified as gang experts. Also, the way they maneuver to get the leads that they want to get. So you bring something like this in, I'd be sitting there anchored to a position of skepticism within this specific trial. I have a broader degree of skepticism outside of this trial. But by day 142, I also have a rising bar of skepticism in this actual trial. And then, holy moly, Muck Duck, thank you so much. This is huge. You guys gotta, if you could do me a favor and yell Muck Duck in the chat, that would be amazing. Muck Duck says, too many issues. The officer turned around, goes for the gun, has no body cam. Right, it's not just one thing. You might be able to give one thing a pass, but you've got several. He turns around, he goes outside of the view. He's the only one that sees it. So Mukduk also says the rules of evidence is you are to mark it. He picked it up in a Ziploc bag, not wearing gloves. Collection of evidence rules broken. This is pure BS. Like, this is really a huge question to me. And I think even if you, like, we're all like, this is such a mess. They can't paint the story of the RICO. If this was one case, and this was the only thing, the only shooting they were having me question, I would still feel like this gun being picked up was very, very circumstantial. So far removed to the theory of what it ties to. Then you're going to tell me that it's relevant because it belongs to the girlfriend of somebody that you're looking at, one of the defendants, Shannon Stillwell's girlfriends, and that when you run a ballistics test, you get a NIBIN hit for something that happened in March of 2022. So who had the gun in their hand when they threw it out the window? Who had the gun in their hand at the time of the March 2022 match that you find? Like, there's so many layers. Mukduk lays out a bunch of layers, and then there's more layers. Even just within this one incident. And thank you guys so much. I am loving the chat right now. Look at all the ducks. Thank you so much to Mukduk. Casper getting the multiple U's in here going, Mukduk! Thank you guys so much. Love to see the chat with the support. I don't know, I think it's, this is a big one. And it's interesting because since there's this video, I think the jury is going to pay attention, right? It's a little bit more interesting than a loud, noisy interrogation video. The jury is going to be tuned into this, and I wonder if they're going to have the same questions that we're having. So, right, what side of the car did it get thrown out of? Like, there's just so much. There's so much. Oh my gosh. And then FFS says, Kat, I had a cop set me up before. I got searched and they found an AK down my pants that I didn't know was there. He definitely put it there. And then one of my favorite inside jokes from this trial with this chat and FFS, I'm telling you the God's honest truth, Kat, LOL, which means it's not the truth. Thank you so much, FFS. You almost had me there. But yeah, I mean, great layout here. Huge skepticism. Like, I don't know. And I think when we see them present it on direct and then on cross-examination, I think we'll see more laid out than we're even able to question right here. So tune in on that day. Whenever they go over this, we all got to be tuned in. And then Violet, good to see ya. Thanks for the kind welcome back. And we're going to leave a duck muck on the screen. I love the backwards duck muck. Let's see what happens with, we're going to have Brian Steele step up to the plate to argue on behalf of Bruce Harvey. Judge Whitaker says, you know what, I'm ready to decide on this, the nested hearsay stuff, like ready to go. And Brian Steele is ready. Hylton's like, I think Love was looking at that. So let's see how this plays out.
Your Honor, it's my understanding that the issue, the legal issue, is that on the wiretap, it seems clear, at least to me, that it is capturing Mr. Garlington's wiretap, speaking with Mr. Stillwell, and they're talking about what other people say, and then the issue that we want your honorable court to wrestle with is there seems to be a break because some of the information comes from a man named Rel, who nobody is alleging is part of this conspiracy.
Right, and what Garlington is repeating, he only knows because of what Rel told him, right?
That's my understanding. So dealing with that, the state's position is if it comes from, the way I understand their brief, and it's that short page, I forget what number, but I have it. But they cite a Second Circuit case, I believe, my memory, saying that if it comes from a co-conspirator, you don't have to apply it's 801 D2E, then therefore you don't have to apply the hearsay, double hearsay, or triple hearsay exceptions. And I don't believe that that is.
I mean, I understood their argument to be like, you don't have to have, the person saying it doesn't have to have personal knowledge, but that's really not what would keep it out. It would be, it's still nested hearsay, and so there would still have to be a hearsay exception for the nested part of the hearsay to come in.
That's my understanding.
Yeah.
And that's under 24-8-805 in the Georgia Code. And I would like to give you a couple cases if I could. And
Well, if it's just for that proposition, I already think that proposition is the law. So you don't need to. You can cite them for the record if you want to.
Sure.
But I'm with you on this part.
Okay.
Have a good one,
And
Steph,
I
JK.
believe that I sent this, but if I didn't, I apologize. But I have several cases. I have copies if you want them. But Lewis, Lewis versus Odom, Odum. Your Honor, it's 2022 U.S. District Court Lexus 19227. Westlaw, if anyone needs this, 2022 Westlaw or WL 304671. It was decided January 3rd, 2022 in the Southern District of Georgia, Augusta Division. And would you like a copy?
Yes, please.
Your Honor, would you like a copy?
Sure, if you've got one.
I do. May I approach?
Yes.
It says exactly what the court just announced, and it's allowing me just to make the record. And if you look at the copy of the case I've given the prosecution, this honorable court, the Honorable Ms. Percifield, it's on page 15 of 17 on the right-hand side. The first full paragraph, or maybe the second paragraph, it starts with moreover. The state habeas court ruled Mr. Peel, P-E-I-L, did not provide ineffective assistance on this point because such argument was meritless under Georgia law. In denying relief, the state habeas court ruled as follows. Under OCGA 24-8-801 D2E, a statement by a defendant's co-conspirator made during the course and in furtherance of conspiracy is not excluded by the hearsay rule when offered against the defendant. Furthermore, under 24-8-805, hearsay included within hearsay shall not be excluded under the hearsay rule if each part of the combined statements conforms with an exception to the hearsay rule. And that's what you were just saying. And then in that case, they found that every part of the statement did meet an exception to the hearsay rule. And I don't believe, it's my challenge to the state, that I don't believe that there is any exception I can think of to woman rel or Mr. rel, R-E-L, the way I read it. So that's my issue before the court, and I think it breaks the chain, therefore, because it is just hearsay without an exception. I have an 11th Circuit case as well, and that is United States versus Barsoum, B-A-R-S-O-U-M. Your Honor, it's 763 F3D or F3rd 1321. It's 11th Circuit 2014. May I approach?
Yes.
Can I give you a case? And Your Honor, in the copy I've given this honorable court, Ms. Persifield, prosecution, Honorable Carty Matthews on page 14. It's in Division F, as in Fox 2. On 14, it's under analysis on the left-hand side bottom, and then on the right-hand side, the first full paragraph, the 11th Circuit wrote, "We affirm the district court's decision to admit this portion of Stevens' testimony because it did not relay any out-of-court statement." And then if you skip, Your Honor, 8 lines down to the right, the court wrote, "Stevens' testimony references the existence of conversations with Wabi, W-A-H-B-A or WABA, but does not convey an out-of-court assertion. Instead, Stevens testified only to his personal knowledge, namely, what led Stevens to believe WABA understood that prescriptions were fraudulent." And the next paragraph, "We also disagree with Barsum's argument that the government had not sufficiently established a conspiracy involving WABA and Barsum as co-conspirators," and they go through that. And then at the very bottom of that section on the right-hand side, same page 14, the last 2 lines, "Thus, even if Stevens' testimony conveyed out-of-court statement assertions by WABA, we would find no abuse of discretion because the evidence showed that there was a conspiracy involving WABA and Barsum, and that WABA's statements to Stevens were made in the furtherance to further that conspiracy. We therefore need not address whether the admission of Stevens' testimony was harmless." My point is, if it was simply the way the state said it, they would never go through an analysis that the person was not relaying an out-of-court statement. It was based on his personal observations. So those are the cases that I found that I thought would assist the court. I know you already said that that is your understanding of the law as well. So I believe that there's a chain broken, and therefore I would ask the court to exclude that conversation of the wiretap, or that portion of that conversation. It's a long conversation, but that portion.
And what's the state's response?
Thank you, Your Honor. The state's response, and we'll speak specifically to what we believe Mr. Nichols may or may not have said to Rel, because that is the chain that I believe defense is saying is unbroken, is not broken, or is unbroken, because we have Damikian to Mr. Stillwell saying that Quamarvious, so those are 2 co-conspirators, so Quamarvious, co-conspirator, told Damikian.
Okay, hang on. Nichols is back up and just say that again.
Sorry. All right. So the chain, as we understand it, is Damikian speaking to Mr.
As we understand it.
Stillwell, and Mr. Damikian is now conveying what Quamarvious told him. Right.
Quamarvious.
Greer, who is a co-conspirator. That statement that Quamarvious Greer says is, "I spoke to Rel."
Right.
And Rel told me that, or Quay needs to chill because Quay is saying that he needs to pay for our lawyer because we did this stuff for him. That's what Rel is telling Quamarvious. Excuse me. That is what Rel is telling Mr. Greer, and Mr. Greer is now relaying that to Mr. Garlington, who is now telling Mr. Stillwell.
So which Quay is this?
The Quay who made the statement to Rel allegedly is Quamarvious Nichols.
Okay, that's what I thought. Whose name you didn't even mention in here.
Because I'm just trying to get the link together first. So what we have is Quamarvious Nichols speaks to Rel. That's what we believe. If we believe what Quamarvious Greer is saying, Quamarvious Nichols talks to Rel.
And says, "Tell Betty, dang, get a lawyer."
Because we did this for him.
Yeah.
And that is now being communicated from Rel to Quamarvious Greer to Mr. Damikian to Mr. Stillwell. Between Greer and Damikian, that's co-conspirator hearsay. Between Damikian and Stillwell, co-conspirator hearsay. The issue is what Rel said to, what Quamarvious said to Rel. Or excuse me, what Rel said to Quamarvious.
Right, because what Nichols allegedly said, if he said it, would be against penal interest, is what y'all argued before. But it's the Rel portion of this that, where's that exception?
So, Your Honor, I want to turn the court to United States v. Ragosta, which is a January 25th, 2013 case, 522, Fed Appendix 663.
Is this in y'all's brief from? Have you given me this case site before?
I don't believe so. And we have a copy for the court, Your Honor.
Okay. Just love having to do all this on the fly. Okay, what part am I supposed to be looking at?
And Your Honor, on my page 7, do you have a 9-page document, Your Honor?
Yes.
Okay, on page 7 of 9.
Yep.
And if you go to the second paragraph, and it talks about Mr. Ragosa now argues the topic of the conversation between co-conspirators. And I want to specifically go to the fact that what Quamarvious may or may not have said to Rel is not hearsay, because it is a order versus, so listen, when you look at this case, Your Honor, the statement that Mr. Ragosa tried to keep out was a statement in which it was a specific order, and I'm just trying to find the language of what the command was that he was trying to keep out.
Nicola's demand that his sons be paid more money. The conversation contained inadmissible hearsay within hearsay, at least insofar as it relayed that demand, because Nicola was not himself a co-conspirator. Is that the part?
Yes, Your Honor.
Okay.
And so in this case, what we believe is said is a demand that he being Mr. Williams, should pay for our lawyer because we did this stuff for him. It's a demand. It is not, based upon this case, it's not hearsay, because that's what this case is. It's a demand. He's telling.
But that's Nichols who's allegedly saying that.
Who's a co-conspirator.
Right. And if it were Nichols to another co-conspirator, there wouldn't be an issue. It's that he said it allegedly to somebody named Rel, who then repeated it to co-conspirators.
But what they're saying is the command itself is not hearsay.
So I don't have an issue with what Nichols said, because it would come in, if it were to come in, already as against his penal interest, potentially. But just assuming that that's not even hearsay, you still need to get to the part where Rel is repeating something. And how are we supposed to accept Rel's hearsay statement that Nichols said X, Y, and Z?
Because Quamarvious is saying it. Quamarvious is giving so Quamarvious is communicating. Not Quamarvious, Quantavious, Greer. Greer is stating what Rel told somebody else that Quamarvious said.
Right.
So if what Quamarvious said isn't hearsay.
What Rel said is hearsay. Okay. So what's the exception for that?
He's just like, please ignore that part of the chain. Just ignore it. Let it in. Please, Judge.
What he said. If I understand it, Rel communicated what Quamarvious said. So the only thing Rel said is what Quamarvious said. And I guess maybe
that's true. But given that we don't have Rel, it's hearsay, whatever he says. Even if when Nichols allegedly said it, it's not hearsay, or it comes in under hearsay exception. The fact that Rel is repeating it, and we don't have Rel here,
and we don't have
means it's hearsay, right? Right.
Yes.
And so what's the exception? There isn't one. This cannot come in. And do you have one?
No, Your Honor.
Okay. All right, so that takes care of that.
And for no, Your Honor. Guys, all that talk, guys, we talk a lot. I talk a lot. I'm not going to characterize all of you guys in the chat, but I talk a lot about the judge giving assists to the state. Well, this is a moment where the judge gives an assist to the state that shuts them down in the same time. She's like, I'm just going to help you out. There isn't an exception. So there's a little bit of a balancing act there with the assist being helpful or not to the state, but the assist always in the direction of the state, even when the assist is to shut them down. Oh, and Hylton just has to go, okay, and then go back to her seat. Oof. Oof. So yes, technically Bruce won that motion, even though he wasn't present, which is really hilarious. Oh, man. Oh, my goodness. That was good, you guys. The shutdown from Whitaker was good. That was worth watching. Whew. And Peter Ortiz, I agree with this sentiment. I think it's important to keep in mind here. And also, there are some convictions already passed by. Some are up for appeal, I get it. But juries have deliberated on certain underlying things that are being added in this indictment as an overt act. It's been adjudicated, whatever. Some form of guilt has been assigned to certain individuals in this indictment for specific instances. So it's completely valid to say, I'm not sure these guys are innocent of all counts. But the state is making a good argument. I'm going to up this one level. They're making a great argument that they are. Or at least that they can't prove that they're not, prove that they are guilty beyond a reasonable doubt. So I am with you, Peter. A great reminder that, you know, there's probably some gray area here, but whether this should be a RICO prosecution at all is my big question. Oh man, thank you, Peter, for the 10. And then Muck Duck, you guys, thank you so much for showing the love. I always appreciate you guys for being so kind to everybody in the chat. But Muck Duck says, thank you for the love. Thank you for all the love, everybody. Love to see it. And then Eek Geek, I'm sorry, I had pinned your other chat. I pinned this. We're going to have to queue it up and circle back to go and check that out. We're going to rewatch that video with the car being edited. How much more did they go through in this day? Looks like they take a little bit of a break. We can turn up the speed, and I think we can get through this, and then we can circle back. Thank you for the 2. We will go and rewatch that car clip. And then Muck Duck gifting another 10. So here we go again. If you got a gifted membership, make sure you say thank you. Super generous. And again, when someone gifts memberships, it's fun for the chat because you guys can use the channel emojis. And I don't really do member gated content. I like everyone to be able to make it on board and hang out with us, but there are plenty of emojis to use, so make sure you use them. And even if you don't know where your gifted membership came from, just drop a thank you in the chat. And then if you guys are okay with it, we can watch on a faster speed to get through the end of the day in the housekeeping and then go rewatch this police video. And then Peter Ortiz. I think Peter and Muck Duck are doing a hybrid gang thing today. Peter Ortiz just dropped 10 gifted memberships in the chat. So there we go. There's 10 more dropping. I see some new green names in there. So you guys, oh, and look at that. Rice Street got a membership from Peter Ortiz. That is awesome. Love to see it. See lots of new greens. Big thank you to Peter Ortiz here. Oh, good times. Now, you guys okay with doing like 1.75? You guys want to just yell at me if it's too fast to get through the rest of the day? We'll see.
Can I ask a question?
Yes, I may not know the answer, but
Can I check one second?
sure. We still have a lot more to circle back on. Does anybody need, why don't we take a bathroom break while y'all do that? Okay.
So this is the break, so we can skip this part. Rice Street was freed from Rice Street. Alright, they're muting us again. Alright, I'm always scared to fast forward through this type of stuff because I know I'll miss something and then YouTube will do the endless buffer. Still muted. There we go.
All right, so the next thing I see is on, back with the wiretaps, on reference number 2158. We were going to circle back on that one also.
Is that the one that was on?
Yeah.
We're going back.
Y'all were going to look at with others in narrow. No, never mind. Sorry, that was the next several. So I don't know why we were circling back on 2158, frankly.
Is that 28 There might be, okay.
I don't know. No, it's 40, I don't know how long it is.
Holy moly, what are you guys doing with these
Anybody
gifts?
know?
It's like a gift war. Mucked Up just dropped another 20 gifts, you guys. Ah, holy moly.
Look at it, I'm gonna go ahead and see what this is.
Okay.
Alright, I will slow it down when they start talking about anything of substance, whenever they get it together. And then Peter Ortiz, look at this back and forth. What are you doing? Aw, I love you guys. Peter Ortiz dropping another 20 gifted memberships. That's so much green.
Yeah.
So, it just seems like they're trying to get themselves together. Alright, let's fast forward till we see like captions pick up.
Right.
Oh, right there we go. There we go.
Back to 2158?
Yes, Your Honor. I was trying to find out who the call party was.
Right, okay.
At this point in time, this specific call, they're talking about wanting to blitz somebody, like shoot somebody.
Right.
And so I told the court that I need to know who Mr. Garlington is speaking with.
Right.
He mentioned talking with Mr. Copeland, but so at this point in time, the state does not intend to use this call.
Okay.
Because, so that's the state's position regarding that specific.
All right, thank you.
Yes, Your Honor.
And then the next one, well, you were going to obviously look at a bunch of those that kind of dealt with the same thing, and if you hadn't had a chance to do that, yeah, that's fine. But the next one was, let's see, reference 1384, page number 1394. You were going to like get the timestamps together better, and then we were going to take a look at it again. Have you had a chance to do that?
Your Honor, I believe, I want to double check if that's the one that was 28 minutes.
This was Dorsey.
Oh, understood. Speaking on Antonio Sumlin's wiretap.
Right. Yeah, oh, yes, I'm sorry. I switched pages and I didn't tell you that. I'm sorry.
That's all right, Your Honor. The state has not.
If you hadn't had a chance, yeah.
I have not yet, Your Honor, but.
Okay, that's fine. And then I had a tab by the one that's 0 or 1892. Was there something, maybe you were gonna, I don't know why that one's noted. Polo.
Your Honor, can you say that PDF page number one more time?
1892.
And what was the court's notes regarding 1892?
Just, I had a tab by it that, and I had circled the timestamps, but I don't know why. Sorry.
I know for that specific call, we were only intended on playing the first 40 seconds and 1 minute 30 seconds to 1 minute
Right.
5 seconds.
Yeah.
My memory, I'm trying to pull up that transcript, that there was a portion, one of those two sections that.
We're going to take, well, I mean, I'm looking at what y'all have summarized. I can come get you tonight. We can do that. I'm talking about hit that boy like 2 or 3 times. We gonna rock out on that tonight?
Correct, Your Honor.
Anybody remember that at all? Maybe I just randomly put a sticky tab there for no good reason. Do you have a note that I ruled?
Your Honor, I'm trying to pull up my notes.
Okay.
I do not have a note.
Anybody?
On that.
No idea. The second purple tab. Do you have anything else we still have?
You know, while they do this housekeeping, I know last week I said, hey, Monday, Sarah Boone's supposed to start, and Hella at Excited Utterance is going to be covering the Sarah Boone trial. Well, that got postponed because that case was in Orlando and they shut down for the hurricane preparation. That should be picking up tomorrow, and Excited Utterance is going to be covering that. So, repeating my recommendation for the week, she's going to start those streams at 6 p.m. Eastern, doing the trial rewinds for Sarah Boone each and every day. I'm going to grab her link. Interesting trial there. That's the suitcase one. Gosh, wait, are we gonna, let me just go forward. Oh. See, look, as soon as I do it, they
Your
go.
Honor, I'm trying to pull up my.
I know, you are. I just meant like, well, I know you're looking. Does anybody else say you're on this side of the room?
I don't have that.
Not yet.
Okay, well, in the meantime, while Mr. Atkins is looking for his notes, what other items can we handle today? I know at some point Mr. Williams, and obviously Mr. Atkins came back in, so maybe there's more we can deal with all that. But I want to distract you, and Mr. Williams is gone again, so she's with Ms. Hilton now, still working on it. Okay, yes.
Yes, Your Honor.
All right, Mr. Mack.
Yes, Your Honor. I'd like the court to consider Overt Act 102 on page 41 of the indictment.
And I would like the chat to consider the Honorable Rice Street. This is the only time we can say the Honorable Rice Street is this Rice Street. I'd like you guys to take note that Rice Street has just gifted 10 memberships. That is super generous of you. Also glad that you were gifted a membership earlier. I saw that you were confused. You didn't have a membership suddenly. Sometimes YouTube's just funny like that. They just kick you off a membership. And then you gotta renew it and it'll tell you you've only been a member for 1 month. So we are glad that you are back, and I am very grateful that you just gifted 10 memberships. You guys say thank you to the Honorable Rice Street in the chat. Thank you so much, you guys.
We've talked about it. It's been broached a few times, Your Honor, concerning a Chandler Durham. That name is ring a bell. All right. So in Act 102, Your Honor, it says that defendants Huey and defendants William engaged in a conversation indicating if he don't take it back, he gonna die. So that's the text message.
Okay.
And when the court goes to the indictment and deals with the alleged conspiracy, the court, they have indicted this case as indicating that the conspiracy is that the defendants conspire to associate together and with others for the common purposes of illegally obtaining money and property through a pattern of racketeering activity. So with the Durham facts. They're indicating that Chandler Durham, that his vehicle was taken while Chandler Durham was inside his music studio working, and he came outside and the vehicle was gone. So we have this text message that supposedly took place on March 12, 2020, where Williams is allegedly sending a text message to Huey, allegedly saying if you don't take it back, he's going to die. So I don't see, Your Honor, even if we look at the analysis under 801 D2E, where it talks about out-of-court statements, how this furthers, how this is during the course and in furtherance of a conspiracy, if the conspiracy is to gain.
Hang on,
I'm sorry.
There is a text between Williams and Huey that says if you don't take it back, he's gonna die?
That's correct.
Or directing Huey to tell another, who's the other?
Directing Huey to tell someone if he don't take it back, he's going to die.
Do we know who the person is?
We don't know.
Do we know what the it is?
I'm thinking I'm speculating, but I'm assuming it has to do with Chandler Durham's vehicle that was taken outside Chandler Durham's studio when he was working one night. So if the conspiracy is to work together to illegally obtain property and money through the pattern of racketeering activity, thefts, murder, robbery, and the like, I'm not clear how this is furthering a conspiracy if Williams is telling Huey to tell someone if he don't take it back, you're going to die. So I'm challenged with how this is an overt act in furtherance during the course of and in furtherance of a conspiracy.
And what are you asking the court to do about it?
Well, I'm asking the court to consider that this particular overt act is not an overt act in furtherance.
And to strike it or something?
Yeah. Yeah.
What relief are you requesting?
Yes. Bingo. Ding, ding, ding.
Your Honor, for one, this is two statements of party opponents. And so that's a great argument for closing, to tell the jury that how does this further the conspiracy. So I don't understand the exact relief that is being asked by the court, but the state's position is the state is going to introduce this message, and any argument about what they mean or how this furthers the conspiracy, we can both argue our separate positions to the jury in closing of if this furthers it or it does not. And the jury can decide with this evidence of an overt act between two defendants in trial of a conversation that both of them had with one another.
See, the state can't have it both ways. They can't say that this conspiracy is to do these illegal acts, and then when there's supposedly something that totally cuts against the grain of an illegal act, is somehow furthering the conspiracy.
Okay, well, I mean, they're either going to, I mean, they may be able to prove that that text occurred, but they may not be able to convince the jury that it's an overt act in furtherance of the conspiracy, especially with your apt argument to the contrary, that it seems to be the exact opposite of that. But
See.
yeah, I mean, I think that's a jury question.
Yeah, Chandler Durham is the run that back turbo guy.
But the burden is on the prosecution by a preponderance of evidence to show that that statement, which is Mr. Williams' statement, so I may have a different, Mr. Adams and I may have a different issue because we're a party opponent, but to use against Mr. Ryan or Mr. Kendrick et al., the state would have to meet that burden, not just say, well, both sides can argue it. They're going to have to show that that statement furthered this conspiracy.
Okay, well, that's a different objection. To get to the evidence even coming in. Mr. Adkins.
Yes, Your Honor, I'm trying to pull up, I have a thorough in-depth breakdown of this conversation, what's said before and after that. I can't rattle off memory this moment, and so I'm trying to pull that up, and my internet's not cooperating. So
Is Chandler Durham,
He's not on the witness list.
he's what?
He's not on the witness list.
Okay, is he allegedly in any gang?
No.
He's a very well-known, he's outstanding, like engineer, production person, does a lot of work for very well-known musical artists and other talented people.
Okay.
He's a very well-respected person.
Okay. Did Mr. Williams use him?
Yes.
Maybe that's why Mr. Williams wanted him to tell But he did return his car.
And I think that, I'm joining. I will join, I heard the argument of Mr. Matthews. I will join his cogent argument as well. But I'm still stuck with, I don't see why that comes in. I do understand it's my statement, so I understand that the court may say, well, let's talk about your client, but to say it comes in against everyone, I don't believe that at this point, I don't believe that would be fair.
How that statement can be in furtherance of a conspiracy.
That's
good question.
Thank you, Your Honor.
We need Jeopardy music. Also, while they're doing housekeeping, another very interesting trial coming up is the Delphi trial. And thank you, YSL Tara, for the reminder. Andrea Burkhart, an incredibly insightful person, great person all around, does a lot of appellate work, has had successful appeals. She will be going in person to this trial. There's a lot of issues with this case, and she did I think it was like 40 minutes. I watched it this morning. Great rundown of why she feels compelled to go down to the courtroom for several reasons. One of the reasons is the judge's pushback against transparency in the courtroom, which is a huge issue, something that I hate to see. I think we need sunlight as often as we can get it. And Andrea, I respect all of her thoughts and insights, but I appreciate that she's going in person to this trial, because you think someone kidnapped some girls, crazy, put them under the jail or whatever. But there's so many evidentiary issues that this guy really might not have done it. And they're fighting so hard. The state and the judge both are fighting so hard, in my opinion, and a lot of people's opinions. I think the sentiment is growing to deny this man the opportunity for a fair trial. Why are they trying so hard to deny it? So if you're interested in cases like that, or you're just interested in great insight, I'm going to link to the video on the Delphi murders that Andrea published a day ago, but just hit the subscribe on her channel anyway. Great person, great coverage. So there's Andrea's link there. Thank you for the reminder on that, because that trial is supposed to be kicking off. And then let's see what we get with the remainder of this.
Ms. Abbasi, do you have any idea, like, where they are, how much, if they have made progress, how close they might be to finishing?
Okay, well,
Thanks.
I don't even want to make a guess.
Okay.
Skippity-doo-dah. Music? The captions say there's music? What music?
Disappointing.
Progress. Not many agreements is what's, yeah.
Disappointing. All right, I tell you what, why don't we end for the day, make them keep working. You're letting them know they need to keep working. Ms. Abbasi, maybe you could assist in that?
Yes, Your Honor, I don't know if this is the type of thing that perhaps both sides could present to Your Honor what they think should be redacted. And Your Honor could make preliminary rulings, and if we want to argue further, we can do that. But that would be versus using the court's time with everyone sitting here listening to the back and forth.
I mean, that's fine with me if it's fine with everybody else.
Your Honor, I think that's a great idea.
I'll discuss with the other attorneys how they feel about that. But I think that certainly would free up quite a bit of the court's time.
Yeah, I mean, yes and no. That just makes me have to do it as homework, but that's fine. Sometimes it's easier to
You can at least, do it in your PJs.
Yeah.
More comfortable.
That would be fine, as long as it's fine with all of the other defendants. Okay. So, Mr. Atkins, just whenever you do, find your notes on that. And, you know, it may, hate to say it, but it might be easiest to just look at the live stream
Your Honor,
since we have it available. Okay.
And specifically, that was Mr. Sumlin's 1842.
Yes, 1892.
Thank you, Your Honor.
Okay.
Sounds like they're just confused on
All
what
right,
they're
and then
continuing to
y'all are
litigate for
gonna-
Sumlin.
When is it that we're going to, I don't know, when we're going to take up the contents of the cell phone, but the way we left that, I think, was that the state was going to get to the defense, the more narrow, what it is that the state intends to, or would like to use from that. Yeah, of Stillwell, yeah.
So I have one, we can get to about.
That's fine. All right, so I think everybody has, are we going to pick back up on Monday with Bernie and finish with him? And then should we be able to generally follow the order that's there?
For the most part, Your Honor, now, if we're being excused now, I will get the list together that I normally will do on Fridays, give it about.
Yeah.
And I'll send it out, ideally the order that you'll have in there.
Okay, and I don't know how much time y'all need to get a response in on Mr. Steele's 3 motions he filed this morning. What do you think?
Can we have next Friday, just the 18th?
As long as y'all stay really, really on the ball with all of your witnesses for the coming week.
Yes, Your Honor.
If you don't, I'm gonna.
Yes.
All right.
Miss Hylton?
Yes, sir.
I know you're going to send it out later on, but could you just, while we're here, just tell me Bernie and then who's next after that?
Yes.
Am I still gonna be calling Summer good?
Well, you had Sprinkle, but I mean, we're not jumping back to him right now after Bernie, are we?
I thought we were going to have a few in between Bernie and Sprinkle. That's what I thought.
Hold on. The whole courtroom's like, please give us a reprieve from Sprinkle. Like, please give us a buffer of witnesses before we have to deal with Sprinkle again. Oh, man.
And this is all contingent upon when Agent Bernie finishes. Officer B. Peak, Officer J. Williams.
A little louder, please.
Hang on. So,
Sure, I can tell you first. So B. Peak is,
he's witness number 8. So it won't be McGee, it'll be Peak?
Yes, Your Honor.
Okay.
J. Williams, which he is on.
I'm sorry, Ms. Hylton.
You need to talk closer to the mic, I think.
J. Williams, who is number 9.
Yep.
Number 14.
Can you try the mic again, please?
I don't know how much closer I can.
Is it on?
It says it's on.
Sound like it.
I don't know. We're back with all kind of sound issues again today. I think these things must just drain batteries.
Okay.
All right.
Can you hear me now?
Yes,
All
better.
right.
Woo.
Sure can. No problem. Officer B. Peak, who's number 8.
Yep.
Officer J. Williams, who is 9 and 14.
Okay.
Ms. Good, who is 15, and she'll be talking about 2 incidents. Sergeant Fernandez, who's number 16. Crime Scene Tech Green, who is 39. Officer S. Holt, who is 40. And Officer J. Johnson, who is he's at 198 St. Hope, number 30.
Okay.
Thank you.
Excuse me, will any of those be on video blackout requested not to be shown?
Question.
None of those individuals, no.
Thank you.
Okay. And that's just for Monday, right?
Yes, Your Honor.
Okay. All right. So you'll send the rest of the list out later today.
Yes, Your Honor.
All right. We are adjourned.
Thank you.
All right, so thank you guys in advance. Like earlier when you guys were keeping us in the loop that there would be court on time tomorrow with the jury present. They're going to have witnesses back on the stand. And again, I feel kind of bad for Atkins and the expert witness that this presentation of the timeline of phone calls dialed out and inbound around the time of the Donovan Thomas murder back in 2015, their presentation gets interrupted by like this week-long break. So that kind of sucks. But, you know, if Love sped up her direct and redirect and her time management, they could have gotten through at least Directive Agent Bernie before this week-long break. So win some, you lose some. I thought it was pretty interesting information that Agent Bernie's covering. And obviously that information, as it's being presented on direct, is helpful to the state's case. And we'll see the defense cross and do their regularly scheduled annihilation, but just saying, just saying. We are going to go back and watch that police dash cam footage. So let me cue that up. And specifically, we are going to want to look for the car turning around and seeing if there's a cut, a jolt in the video. So that's what we're going to be keeping our eyes on. Before we do that, big shout out to Peter Ortiz for the nut juice mention. I heard nut juice is back. Is that true? No, it's gone. There's no such thing as nut juice anymore at all, ever. The word doesn't even exist. The phrase is outside of our knowledge. Just forget it. Mind wipe it. Ugh. Thank you for the 2, Peter. Chloe Albert's Revenge says, so according to the state, if you're playing on some train tracks and say, if you keep doing that, you're gonna die, I can't just be warning you. Exactly. And I don't know if you were here with us when we did the rewind, I think last weekend, on the bond hearing, the first bond hearing, where the state makes the argument to deny the request for bond for Jeffrey Williams, for Young Thug, because he's a danger, he's going to intimidate witnesses, and what they point to show that he's going to intimidate witnesses is an issue where Jeffrey Williams is hoverboarding at a mall, and he gets into a verbal altercation with the mall security guy, and says, if something to the effect of is, the if is part of it. There was an if, and that's my point. But I don't know the exact quote. It was like, if you don't back off, I'll shoot you in the face. And it's the same concept, right? It's a verbal thing. And it's not saying I'm just going to assault you or shoot at you for no reason. It's, if you don't get away from me, if you don't remove yourself from my personal space, from what I might perceive as a threat to my own safety, I'm going to do something about it. And to me, that sounds more like a warning rather than some big, scary, like, actual plan to carry out a violent act. So I'm with you, Chloe. A great observation there on that language. If you keep doing that, you're gonna die. Yeah, like the if. There's an if. And Dolly Talk, thank you so much for gifting 5 memberships. You guys, if you got a gift from Dolly, make sure you say thank you. And Dolly, I don't know if you were here earlier. It was towards the beginning of this stream. But earlier they were making a mention of Dolly, like D-O-L-L-Y, like Dolly Parton, Jeffrey Williams' sister's nickname, and Big Nick. but audibly, it sounded like they were talking about Big Nick Starro and Dolly Like You. So I was making some jokes about you guys with love. So I don't know if you were here. But shout out to Dolly Talk. Love Dolly Talk's commentary. I think some of you in the chat are getting to know Dolly very well and are seeing what I mean when I say listening to him do voice readings and impressions is just makes my day. Always a good time. Dolly, will you be this week mostly on the Sarah Boone streams with Hella? Or are you doing separate streams on Wade Wilson? How are you balancing that? Because I don't want to say, hey, we're going to be doing a Wade Wilson stream, and then you're not. And this is Dolly's channel, you guys. I know the mods. Thank you guys for dropping it already. I'm guessing, I'm pretty sure that Dolly will be co-streaming, co-hosting on Excited Utterance's channel, Hella's channel, for the Sarah Boone stuff. But also, of course, he's got content you can check out. If you want to binge in the Wade Wilson case, that is the place to go. Always good to see you, Dolly. Thank you so much. We can pull that up and see what the motions in limine were. I'm not sure I feel like I saw a lot of stuff circulating on Friday, and maybe I'm forgetting, but I don't think I actually saw those pop up anywhere. So I can pull up and see if those are something new. Jeffrey Williams. And then Black Butterfly says the testimony showed it wasn't Thug who said that. So we are going to rewatch day 9. We are going to watch day 9 over on a rewind when the mall cop actually takes a stand. Thank you for that, Black Butterfly, because I used to just listen while I worked, and when I do those rewinds, I hear stuff for the first time for real. Like, you really think you pay attention to something? And even when I'm streaming, I should be paying attention. Sometimes I look at the chat and I miss something, and you guys are like, you just missed that. So definitely can't wait to rewind on the mall cop's testimony. That will be a day 9 rewatch. So when you see the day 9 in a video, that's what we're going to be looking at. And also, big thank you while you're here, Black Butterfly. Thank you for the Cash App I saw for your generator donation. A big 20. Thank you so much. Super appreciate that, you guys. And I want to thank you guys in the chat again for having so much like tech conversation about these generators and, you know, what a UPS uninterrupted power supply. Is that what the acronym is? Like, you guys really helped me narrow down the choices and having to pick out what I'm supposed to order. I get overwhelmed when there's a lot of choices. Like, if we go to a diner and they put a huge menu in front of me, I'm going to order like the same 1 or 2 things every single time because it just gets overwhelming. Okay, yeah, so that's definitely going to be a good rewind, and hope you're able to be there with us when we do that one. I see the mall cop Blart, the Paul Blart references. Oh, man. Oh, my goodness. And then I'm also pulling up, let me see these motions here. We're also going to replay this dash cam video. October 11th. Let me open them. All right, so there's 3. They're all 4 pages. Each of them are 4 pages. So what I'll do is we're going to replay this. And I don't know the exact part we're going to be looking for this cut, so I'm going to rely on you guys a little bit. I'm going to download the files, get them in Google Drive so I can share the links with you, and then we'll look at those motions in limine. That's what we're going to do here. So let's play this video.
Where? What's that one?
Was there a warrant at the time? So are these people trying to get to where the Audi is?
So what number of details come into
Trying to get there. Yeah, I mean, is there an Audi in?
Helicopter's calling out over radio.
Right. So these are officers who are like, oh, I can help with this chase. Let me get to this area.
Yeah, so now he's directing us to where they are now.
Right. Okay. And so why would it be relevant? We're just watching it all now, but this part is not anything you're going to offer. Right? Okay. Can you skip to the part that? Okay. Does GSP cars go fast?
Whitaker is loving this. He's like, oh, fast.
There was a gun back there. There was a gun in the street. I'm gonna go back and get it. Boulder Way and Meadowlark. Meadowlark, the west Meadowlark. Meadowlark running off foot.
And do we know whether this is the same route that the Audi took?
Yes, the Audi, we know from the helicopter, it's the same route.
that gun? Huh? Did y'all get the gun?
Through the fence to the right of the house, 3 male.
It was in the street.
The house where Amber is on this street.
Hey, somebody can get over to Ford Drive. Ford Drive, that's where it's at, where it comes out to where they're
Is
running.
this officer going to testify?
Tony, you out there? Did you give an update?
Hold on, let's rewind because it would be right before this, right? Okay, so as this car is turning,
Yeah, I'm out here. I'm trying to get to where they're running to.
Takes it and gives it to law enforcement. That gun is significant because.
Do we see the gun on the camera ever? Okay, let's skip to that part.
Numbers on motorway.
okay, so hold on. Let me move my picture. And it kind of sucks because the law and crime banner is kind of here, but watch the pause button here. So I don't think this is an edit. I think this is Hylton.
Gives it to law enforcement. That gun is
Look, she's hovering
significant
over it.
because.
Do
Like,
we
watch down
see the
here.
gun on the camera ever? Okay, let's skip to that part.
Numbers on motorway.
And so the law and crime banner is blocking where I assume the forward button is. So I think Hylton, judging on her hovering over the plus sign, it being illuminated in blue, and then her mouse disappears to the right, I think the jump is from Hylton fast forwarding because Whitaker's like, hurry up, get a move on. So I'm sure we'll see more when they actually decide to play this. Hopefully we'll get whatever portion they start at and stop at. Hopefully it's a continuous clip with no jumps. But still, like, great observation there in any case. And, you know, as a chat, we are here figuring it out, and that's good too. So also in the meantime, I did get the 3 motions in limine. We did hear them discuss. One of them is the request for the entire prosecutor team's work product file. So that was one of them. I'm going to drop, and when I'm done, I'll also add the links in the description. Let's see. Copy link, manage access, share with all. But if you guys want to download these files on your own, this one is a motion in limine about mens rea. This next one is a motion in limine about the use of jargon by expert witnesses. Share with everybody. I'm just going to call this one jargon. And then the third one that I'm dropping is the one for the work product, the state work product, which I'm sure is going to be hilarious, although probably not successful, but we'll see. And then work product. So those are the 3 links. If I forget to go add them to the description later when I'm not multitasking, just nudge me. I'll add them to the description. I can be pretty forgetful when I end a stream. But let's start with this work product one. So, I think these are all Brian Steele, I think. Right? They said all 3 were Steele. Make this bigger. So motion for the entire prosecution team's file, internal memorandum, work product, all persons involved in decisions, contact information, all witnesses, and the like. Okay, so this is a bit more than just asking for work product. It's also like, what's the basic contact information for us to speak with and maybe request to interview the witnesses you plan to call, which the prosecution is supposed to turn over the witnesses and basic contact information to the defense. So not an unreasonable ask. Comes now Mr. Jeffrey Williams by and through undersigned counsel, and hereby files this motion for the entire prosecution team's file. Internal memorandum, work product, all persons involved, blah, 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 blah. So we want this honorable court to order the prosecution to provide all this work product, all these internal memos, these emails, text messages, names and contact information of all persons who have worked the above reference indictment, and all other information of anyone who gave statements to the prosecution, quote, team, so that Mr. Williams can evaluate whether to voice an objection to the purported testimony of Deputy District Attorney Michael Sprinkle, Esquire, that Lawyer Love stated that she wishes to elicit as to explain his reasons to indict Mr. Williams and the others accused in this case. In support of this motion, Mr. Williams shows as follows, and I was waiting for it. You know, we usually see this higher up on the page. But 1, Mr. Williams is innocent of all charges in the above referenced indictment. 2, Lawyer Love announced on October 10th, 2024, that the state will seek to elicit testimony the Honorable Deputy District Attorney Michael Sprinkle, Esquire, as to his reasons for indicting this case and charging the people in said indictment, including Mr. Williams. Now, the 10th was the day that they didn't have cameras. They were meeting in chambers in the courtroom because they needed the space. So this happened on that day, October 10th. But yeah, so in order to properly prepare for cross-examination of this purported testimony, Mr. Williams now needs access to all internal memos, emails, text messages, meeting notes, photographs, recordings, any work product, and the like, so that he may obtain the proper information to challenge and confront Deputy District Attorney Sprinkle's potential testimony. By putting forth Deputy District Attorney Sprinkle's thought process on why charging decisions were made, all privileges / work product / internal thoughts of the entire prosecution team must be deemed waived in order to permit the constitutional right to cross-examine. I think this is a chess move. I think this is to get, and I don't think Love will say, all right, we're going to back down from trying to elicit this testimony from Sprinkle, but I think Brian Steele is filing this to get the judge to look over at the state and say, do you really want to put this testimony forward? So I think this is a chess move from Steele. I don't think it's a literal expectation that the end result will be the turning over of this work product. It will just be to preemptively get the state, either by a force of hand from the judge, to reconsider eliciting this testimony in the first place. And then 5, so it is odd to fathom that this testimony would be admissible under OCGA 24-4-401, OCGA 24-4-402, and or, shout out to our favorite, OCGA 24-4-403. As same takes away from the presumption of innocence and would place the credibility of the district attorney's office on the front row for the jury to weigh. If this honorable court permits this testimony, or is entertaining their permission of this testimony, Mr. Williams respectfully asks that he first be given ample time to review all the above information requested and any other information that is relevant to confront Deputy District Attorney Sprinkle on why he would indict Mr. Williams. Thus, all the above information must be released, including all thoughts of the District Attorney's office, the police investigating this case, all witnesses, and the prosecutors. Without same, there can be no meaningful cross-examination of Deputy District Attorney Sprinkle on these issues. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of the same, asks this honorable court to grant the above requested relief. So, and he ends up filing this on the 11th. So, what are you guys thinking about this? I think it's a chess move. Just to get them to say, like, look, we're not going to sit up there and have Love, like, elicit a super bolstering testimony from Michael Sprinkle, of Michael Sprinkle's own work and the work of APD. So, and I think it's great that he also cited, like, I don't know why this testimony would be admissible based on these three things. So, I'm her. Shout out to getting power back. That is great news. That is great news. And guys, just so you know, there are 2 options. You can either have YouTube flag comments or You can have them not flag anything. This channel, the chat is set to, by YouTube, to automatically flag contents. So if the mods are saying YouTube flagged it, that might not happen in another chat because that setting isn't turned on. But the flagging is still, if the feature's on, the flagging is coming from YouTube. So that's why it seems like inconsistent. And I'm sure there's still inconsistencies. We're talking about YouTube. But just so you guys know. Yeah, that's true, Jenny. Love doesn't have to elicit it. Sprinkle will just spill it on his own. I also think that's true. Great point. Great point. Oh my goodness. And sorry, Lucia, still having internet issues with Spectrum. Seems like a few hours on and the rest of the day off. If you have Spectrum, they will give you an outage credit if you ask through the chat. Yeah, I should probably try. Sometimes I'm too lazy to go through the customer service chats, but I might as well. Especially next time I don't have power anyway, or internet anyway. Just pull it up. Thank you for the tip. I hope you get your internet restored consistently and permanently soon. But yeah, I definitely think that this was a chess move here. The next one, motion in limine number 65. You know how it goes. We're going to start off. Mr. Williams is innocent of all charges in the above referenced indictment. Courts may permit a qualified expert to testify about jargon or code that is used by certain accused if proper foundation is laid. However, the officers/experts' testimony must not go beyond the plain meaning of the recorded communication. And we're getting a cite to United States v. Delpit. That's an 8th Circuit case from 1996. The officers/experts' testimony is inadmissible where it pertains to ordinary language, and the jurors can make a common sense determination of the evidence without the technical aid of the expert. So I think, like, for example, you guys, what does down bad mean? That might be a common sense interpretation that the jurors should make, just like you guys in the chat make, rather than an expert coming in and telling you, well, that can only mean this. So, see, and this is going to United States v. Roadboff, 8th Circuit from 2009, but vacated on other grounds. Moreover, an officer/expert's testimony may not rely merely upon hearsay testimony of a non-witness. There you go. So we can't also just have this expert, you interpret jargon that should be interpreted through the common sense of the jurors themselves, when the interpretation is of a hearsay statement from a non-witness. So that is a cite to United States v. Avalos, 8th Circuit 2016. On or about Wednesday, October 9th, 2024, or Thursday, October 10th, 2024, the prosecution announced that it intends to have Investigator Viverito, a supposed gang expert, Steele, who has never been qualified before this case as a gang expert or an expert in any field, to testify as an expert in gangs as to wiretap conversations and what the communications meant. Mr. Williams specifically objects to this improper testimony because possibly some words which are beyond the ken of the jury may be permitted to be defined by Investigator Viverito if a foundation is laid, but Investigator Viverito cannot give the meaning of the conversation, as most of the words are understandable by the average English-speaking person. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, asks this honorable court to grant the above-styled relief and bar this overarching testimony, where the prosecution improperly has another closing argument to impermissibly promote their theory of the case. Oh, this is a sharp line right here. This is a sharp argument. Steele saying, once again, you're doing something that you should argue during closing arguments as an argument, and not present through the testimony, because the jury can consider testimony as evidence, whereas a closing argument isn't evidence. But Love consistently has tried to inject testimony, her theory of the case, throughout her own questioning while particular witnesses are on the stand. This is a hell of a sentence right here. Shout out to Brian Steele. Love that there. And what was our last one? This was, oh, the mens rea. So this one will be good. Guys, I don't know how we consistently get the same person spamming in all caps. I don't know how that happens. Guys, it's pretty simple. You can have a different opinion in here. It's honestly appreciated. But don't just spam. Like, give us something a little bit more to work with. Give us more to work with. But motion in limine number 64. So we're going to look at mens rea, intent, what's in somebody's mind when they do something they're alleged to have done. So, comes now Mr. Jeffrey Williams by and through undersigned counsel and hereby files this motion in limine number 64. So we're out of order, my bad. To preclude any expert testimony which goes to the state of mind / intent of Mr. Williams concerning any element of any of the above referenced charges. In support of this motion, Mr. Williams shows as follows. Mr. Williams is innocent of all charges in the above referenced indictment. In a criminal case, an expert must not state his / her opinion about whether the criminally accused did or did not have a mental state or condition that constitutes an element of the crime charged or the defense, as those matters are solely for the trier of fact. So, think of that last sentence we just read in the other motion. The habit of the state, what the state consistently tries to do. Oh, you know, we just try to improperly inject things through a witness. So, here's another issue where we're trying to file this motion in limine, so the judge makes an order, a ruling in advance, excluding that type of thing from the state. Let's see if Whitaker grants it. Let's see if she agrees to this. And this is according to OCGA 24-7-704B, which bars any expert witness from giving an opinion about Mr. Williams' mental state / intent concerning any elements of the crimes charged. And cited here is Diaz versus United States. Deciding whether Mr. Williams acted with a culpable mental state is solely the job of the jury, no matter how, quote, clear of proof or, quote, incontrovertible the inference. Is this quoting like Love or something? I feel like this is quoting the state. So, deciding whether Mr. Williams acted with a culpable mental state is solely the job of the jury, no matter how clear of proof or incontrovertible the inference. The question of whether Mr. Williams possessed a culpable mens rea must always be decided solely by the jury. So see Morissette v. United States. The prosecution bears the burden of proving Mr. Williams' mens rea, and they cannot have any witnesses, expert or otherwise, testify to the jury that Mr. Williams meets a material element of the crime. Even back to common law. All right, so this is a black letter of the law argument. We shouldn't even have to state this. It should just be known that this is the law. But even back to common law, courts barred experts from offering opinions on the ultimate issue on the case, such as mens rea, announcing as codified in OCGA 24-7-704B. Oh my gosh. So we have it in case law, we have it in statutes, we have it from all the way back in the day. The reason that the federal counterpart to OCGA 24-7-704B exists is because after John Hinckley was tried for shooting President Ronald Reagan, and mental health experts were allowed to testify as to what was Mr. Hinckley's intent at a particular moment when he committed the particular act of shooting the president, Federal Rule of Evidence 704B removed the federal courtrooms any expert who claimed to know what was inside of another person's head, some referring to the same as, quote, junk science. Over constant and continuous objections by Mr. Williams, the predecessor judge permitted expert after expert to testify that Mr. Williams and the other accused on trial were part of a criminal street gang, which goes to the mens rea of Mr. Williams and the other person. This was total error in violation of OCGA 24-7-704B. And we've been picking up on some of this argument from the rewinds. Great arguments. We're going to see more as we go through the pretrial hearings. So if you're tuning into those, this will sound familiar. If you've been paying attention, this sounds familiar now. Based upon information and belief, the prosecution is going to recall over Mr. Williams' objection for cumulative additional experts at trial who will again impermissibly read Mr. Williams' mind and state that he is a part of a criminal street gang and sang lyrics to further criminal street gang activity. Mr. Williams continues to object to any testimony that violates 24-7-704B. And I wonder if this is a typo and it's supposed to be the number 4 instead of for this cause. But we request a motion, a hearing on this motion, and at the conclusion, we ask this honorable court to grant the above requested relief. So there you go. Those are motions in limine. So I thought that was, I just think it's interesting that we have to file this to, like, get the court to nudge the state to not try it. Like, normally you wouldn't have to see this filed, but here I understand why it has to be filed. Oh, man. So there you go. Thank you, Elizabeth Wright, for putting that on the radar, because it was great to read through those. Nameless, thank you so much for the 5. We got the peace and the heart and the peace in the heart. And let's see. So FFS says, Cat, a comment is getting flagged for someone saying the inventor of an app was a white male. That's a race comment and it gets removed. But 99% of the most ignorant things that I say, which are way over borderline, people might want to word things differently. Trying to let a chatter know about an issue, not catching an attitude. So if you want to describe that like something is like a small owned business, like a black owned business or like an all female business, that's okay, you guys. I don't know what the chat is actually flagging, what YouTube's actually flagging. But there are certain other times where if you're using race as, you know, a characteristic to mean something like intrinsically, essentially, inherently, then that could be problematic. But yeah. So just in general, the rule is just be respectful. You know, if it is descriptive, you know, I think it's actually important to specify if something is started like a small local business. There might be a reason you want to specify and detail that, because maybe you want to support somewhere where the money stays in the local community. But if it's just like a random description that's unnecessary, weigh the balance. FFS, sorry about that. And I don't know, because I haven't seen it, but I do see the Vera. The Vera's coming back, the troll that finds all the chats and, you know, just in all caps spams the YSL chats. So thank you, mods, for handling that. Yeah, so I don't know. Yeah, and this is kind of my take on it. No cursing keeps everyone a bit friendlier. And a lot of that, you guys, YouTube really does flag stuff if you aren't, like, changing up your spelling. And again, that setting is not on for all channels. So. But yeah, so I don't know. And at the end of the day, I am pro mod love all the time. I mean, it's not an easy thing to see text flying by and try to keep things in check. So respect always to the mods. And I think the mods always have meant well. I've never seen them not mean well. Okay, yeah, and then also I'm noticing the same Copa that Vera will make a lot of accounts to troll. You block one and another will pop up. Yeah, and that's something that I think is outside of anyone's power to control. So, but there we go, you guys. Those are the motions in limine. There are, you know, I think 8 o'clock, 9 o'clock. Did she give it start time for Monday for court tomorrow? Are we just assuming it's 9? I won't be able to start because tomorrow's Monday. I always have meetings Monday mornings, so I always start at noon for trial watch. We skip the breaks. We like always end up getting caught up by the end of the trial day before it ends. So it's nice to be able to skip the breaks on Mondays. So we'll be starting this stream at noon. I believe Lead attorney said that AV is going to be streaming tomorrow starting early in the morning. Classy Beats is going to be streaming in the morning. So if you guys are lost in the YouTube streets, there will be streams for you guys to go hang out in. But I will be starting at 12 noon. And I think Friday, the state's supposed to respond to the motions that we just looked at. So maybe we'll hear some rulings or arguments on those orally Friday. Friday, we also have the probation revocation hearing at 4 p.m. for Munktunk, so I'm looking forward to that. And heck yeah. Jenny says, Mlat, they are so helpful answering questions. They really are. The mods are so knowledgeable. And that's 5 p.m. in Ireland. I think talking about noon as a start time, right, for tomorrow. My time zones are awful. I have no concept of... I have to look up on Google every time I need to convert a time zone. And then Chloe Albert's Revenge, thanks for the super, says, Love should drop this case and bring up all Vera's accounts on RICO charges. It will revitalize her shattered reputation. Oh, man. Heck yeah. Hilarious. I wouldn't have the patience to sit there and create multiple accounts. And, you know, there's been people that have been very insightful in this community that are like, hey, I think this is actually a great argument for the state. And I don't really see you guys jump on them. So I don't really think anyone needs to come in here yelling in all caps. We do make exceptions for all caps for the visually impaired. You know, it's hard to type on a device, see what you're typing with the smaller font. So every once in a while, we have like 1 or 2 users that type in all caps. Please don't think that they're just yelling at you guys. They're doing it because it's easier to type on their device. And the mods, you know, as soon as they know that that user is visually impaired, we've all got an agreement going there. But when you're coming in to yell in all caps to spam and cause a nuisance, don't do that. Don't do that. But there we go. Anything else before we wrap up? I don't have a redirect set up. Is there anywhere you guys want to go? We'll go on a trip. Redirect. Okay, a lot of these are all upcoming, but they look like they're for tomorrow because I see like one of them is like something that's not for several days that's being suggested. Live right now, Down the Rabbit Hole is talking about Diddy. Hold on, is this coming up live? Nope, that's tomorrow. And then Black Law Student has a live. It looks like it might be about Fani Willis. I don't know if it's actually about YSL. It says, where's the money? And it's a picture of Fani. So that is live if you guys want to go over there. And any suggestions in the chat? Yeah, no suggestions. You guys are going to be out here lost in the streets. Usually we get a ton of, you know, hey, this person's doing a stream or is about to do a stream, but I think everyone's going to bed, just like Tip the Scale says. So we'll set up a redirect. It might be like Fulton County content and not necessarily like YSL content, even though there's an overlap there. So just a heads up there. That will be the redirect there. Yeah, Fatima, to be honest, and it was like really overwhelming in a good way. A ton of messages from a lot of people, and a lot of it was just, we are worried about you. So I think that might have been a blanket inclusion there, which is really sweet of everybody. Yeah, and Copa, that's what I had. Delphi videos, but they're all upcoming. They're not actually for today. Well, so let's end the stream. Again, this is going to carry you guys over to some Fulton County commentary from the Black Law Student. I don't know if it's YSL, but maybe it will be, because how can you not overlap that? So with that being said, thanks for doing this day 142 rewind with me, catching up with me. Super interesting stuff. Love to see that Brian Steele step up to the plate argument. That was just really nice. Great teamwork from really, you know, at some points in time, Steele and Harvey, they might have to argue against each other in the individual interests of their clients. That was pretty awesome. That was awesome. So let's get this over with. I'm not going to do the outro, so that way it redirects right away. We'll get some ABCs of Steel tomorrow on tomorrow's stream. See you at 12 p.m. Eastern. Bye-bye.